by invoking section 14 of this Authorized Act.
You are the borrower.
Guarantor.
ಎಲ್ಲ ಒಂದು ಪೆಂಡಿಂಗ್ ಮುಂದಿನ ವಾರ ಆಗ್ಬೋದಲ್ಲ.
Next,
The 16th in all pending matters, getting it posted. Old priority.
old notice,
ಯಾವ ವರ್ಷ?
22.
ಅಯ್ಯೋ ಅದು 16, 17 ಪೆಂಡಿಂಗ್ ಇದೆ, 22 ಮಾಡಿಸ್ತೇನೆ.
But here only a temporary appointment. After 1 year.
No, it may be very small case, but let me follow some method. Then 2011-12 ಎಲ್ಲ ಹಾಕಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಎಲ್ಲ ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇರುತ್ತೆ.
Next week.
ಖಂಡಿತ ಬರುತ್ತೆ, ಕೊಡಿ.
Online.
ಓ
ಏನು
ಪರಮೇಶ್ವರ್ ಆಗಿದೆ ಯಾಕೇನು ಯಾರಿಲ್ಲ ಇಲ್ಲ.
in 230 matter, he wants to mention that by the time the matter reaches, we will be permitted to comply.
ಅಷ್ಟೇ ನಾನು ಅದು ಮಾಡ್ತೇನೆ. ಡೋಂಟ್ ವರಿ. ಎಸ್ ಆಲ್ ರೈಟ್. ಹಾಂ ಕವರ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಯು ಸರ್. ಸರಿಗೊಂಡ್ರೆ ಕವರ್ಡ್ ಇದ್ರೆ ಕವರ್ಡ್, ಇಲ್ಲ ಅಂದ್ರೆ
I make one submission.
ಹೇಳಿ.
Moment can say Annex B, Annex C. There are two of the Marathi order. Page 24, Annex C. ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 9/3/95 ಸರ್ಕಾರ ಆದೇಶದಲ್ಲಿ 1991-92 ಮತ್ತು 92-93 ಸಾಲಿನ ಆರ್ಥಿಕ ವರ್ಷಗಳಲ್ಲಿ ಸ್ವತಂತ್ರ ಹೋರಾಟದ ರಾಜ್ಯ ಗೌರವ ಪೂರ್ವವಾಗಿ ಮಂಜೂರು ಮಾಡಿದ ಪ್ರತಿಯೊಂದು ಪ್ರಕರಣ ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರ ರಾಜ್ಯಗಳು
ಮೈಕ್ ಆನ್ ಮಾಡಿಲ್ಲ.
ಮರಾಠಿ ಸೆಕೆಂಡ್
ಹಾಂ ಹೇಳಿ.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮರಾಠಿ ಇಂಪ್ಯೂಡ್ ಆರ್ಡರ್
ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಓದಲಾದ
995-12-90 ಸರ್ಕಾರ ಆದೇಶದಲ್ಲಿ 91-92-92-93 ಸಾಲಿನ ಆರ್ಥಿಕ ವರ್ಷಗಳಲ್ಲಿ ಸ್ವತಂತ್ರ ಹೋರಾಟದ ರಾಜ್ಯದ ಗೌರವವನ್ನು ಪೂರ್ಣವಾಗಿ ಮಂಜೂರು ಮಾಡಿದ ಪ್ರತಿಯೊಂದು ಪ್ರಕರಣವನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರು ರಾಜ್ಯ ಗೌರವವನ್ನು ಪಡೆಯಲು ಅರ್ಹರೇ ಎಂಬ ಬಗ್ಗೆ ಸರ್ಕಾರಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸಿ ಎಲ್ಲ ಜಿಲ್ಲಾ ಖಜಾನಾಧಿಕಾರಿಗಳಿಗೆ ಮತ್ತು ಜಿಲ್ಲಾಧಿಕಾರಿಗೆ ಸೂಚಿಸಲಾಗಿದೆ.
ಆಯ್ತು.
Malati inquiry held against only Malati who have get the pension in the financial year 1991-92. But in this case, freedom of pension was granted on 14/7/1993.
ಯಾರಿಗೆ? ನಿಮಗೆ?
ಹೌದು. Beyond that period, the inquiry itself is contrary to their own circular.
What is the division bench judgment about?
Division bench judgment is Malati the subsequent notification issued by the central government and in the year 2014, that is not at all applicable to the Malati widows when the inquiry is pending. In this case, petitioner is Malati is a freedom fighter. That's why that is not applicable.
Can I go against the division bench?
But judgment is not at all applicable because he is a freedom fighter. Petitioners are freedom fighters.
No, you are the widow of the freedom fighter.
No, freedom fighters. Petitioners are freedom fighters.
Yes.
Therefore, that judgment not at all applicable.
Pension was sanctioned to the husband of the petitioner.
16/11/93.
16/11/93.
Yes.
It was on re-verification as the government order. It was found that the certain documents were not produced. The 4 prisoners certificates, those are not produced. But the committee was established on 4/3/1999.
No, if you have some shortfall of documents to be verified, they will produce it.
But in this case, the husband of the freedom fighter died in the year 1990. The question of granting freedom fighter in favor of husband does not arise. The third
16/1/1993 you said husband is granted. He was no more by then.
The third paragraph stated in the imputed order.
The earlier writ petition also filed for
Earlier writ petition order is there, Annexure A, page 15.
That's the original cancellation order was not only directed to reconsider.
These are matters of pension. Technicalities or admadilla idmadilla beda. If you are reconsidering in terms of the division bench judgment, we will direct. That's all. We will quash this, send it back. The petitioners are before this court seeking the following prayer. It transpires that the petitioner's wives alla, petitioners say freedom fighters alla. It transpires that the petitioners themselves were it transpires that the petitioners themselves were participants in the freedom movement and were granted pension under the freedom fighter pension scheme by the state government, recognizing the role of these petitioners in the freedom movement. When freedom movement in the year 1993, when things stood thus, it transpires that the respondent cancelled the pension of the petitioners by a common order where pensions granted to several persons stood cancelled. This becomes the subject matter of the writ petition in WP 18004 of 2005. The said writ petition comes to be allowed by the coordinate bench by the following order, page 1920 of the marked portion. Identical orders were passed prior to the passage of the aforesaid order, which was followed by the coordinate bench, and orders were passed directing reconsideration. The reconsideration is what has led to passage of the impugned order, which impugned order dated 3/8/2009. This order is what has driven these petitioners to this court in the subject petition. The learned counsel, H. Dharwad, appearing for the petitioner, H.M. Dharwad, appearing for the petitioner, would vehemently contend that the petitioners are not the widows of freedom fighters. They are themselves freedom fighters who, and recognizing their services, recognizing their role in the freedom movement, pension was granted. It is erroneously cancelled. The submission of the learned counsel for the petitioner merits acceptance. The learned counsel for the merits acceptance. The learned counsel for the the learned counsel for the state, AGA appearing for the state would submit that the petitioner's respective husbands were granted pension on 16/1/1993, and after the directions from the central government, the same has been stopped, and there is no error that can be pointed at the order that is impugned in the subject petition. The learned subject petition and the 12 years.
Delay 2009 order. We gave representation in 2018.
No.
2009 a petition is
Petition, Allah. There is a delay of the consideration of the after their order passed earlier in the earlier petition.
Sir, earlier writ petition 2009, this was on 7. You have passed the order, they have challenged it immediately. Don't, sir. I have given my anxious consideration to the submissions made by the respective learned counsel and perused the material on record. The afore narrated facts link in the chain of events and the dates and participation of the petitioners in the freedom movement is a matter of record. It does not require any reiteration. The learned counsel appearing for the petitioner submits that the submission of the learned counsel for the petitioner merits acceptance on the score that the petitioner's husbands were not granted any pension on 19/1/1993 as is contended by the learned AGA. The petitioner's husband, the learned counsel submits that the husbands of the petitioners had already died in the year 1990 itself, and the petitioners themselves, who are now 83 and 88 years old, 88 years old, 2009 and 88.
Now 100 years.
Information ತಗೊಂಡಿದ್ದೀರಾ? Yes, so. The petitioners who were 83 and 88 years old at the time of filing of the petition were themselves freedom fighters. Therefore, the order that is passed against the petitioners, which is common to all, appears to be incorrect, as those were the orders concerning grant of family pension to the freedom fighters whose husbands were freedom fighters. The case at hand, the petitioners themselves are said to be involved in the freedom movement in the year 1942 and 43, and who are now 100 years. Both ಇಲ್ಲ, both ಇಲ್ಲ. 83 who are the second petitioner who is now 100 years old and the first petitioner nearing 100 years. Therefore, the order so and so, which refers to the husbands of the freedom fighters, is inapplicable to the facts of the case at hand, is erroneous, and the judgment relied on by the learned AGA in writ appeal 100205 of 2022 is inapplicable to the fact situation. In that light, the matter requires reconsideration at the hands of the respondents, strictly in consonance with law, bearing in mind the observations made in the course of the order. For the aforesaid reasons, the following order: allowed, quashed, the matter is remitted back to the state to consider and pass necessary orders within 8 weeks. Within 8 weeks from the date of receipt of the copy of the order. Jaldi ಮಾಡಿ, ಇಲ್ಲರ 100 days ಆಗೋಗಿದೆ. Yes, 1.5 lakhs ಎಲ್ಲಿದೆ reference?
In fact, ಲೋಕದಲ್ಲೊಂದು order ಬರೋದು.
You were lured into it, you were coaxed, ಅದೆಲ್ಲ ಈಗ ಆಗಲ್ಲ.
At least notice is issued for
ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ?
settlement.
1.5 ಲಕ್ಷದ ರೆಫರೆನ್ಸ್ ಇಲ್ಲಿದೆ, ಎಲ್ಲೂ ಇಲ್ಲ. Yesterday you told 1.5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂದ್ರು ಕೊಟ್ಟೆ, there is no reference.
There is reference.
ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ನೀವು ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದು ಕೇಸ್ ಹಾಕಿದ್ರೆ ಈಗ ಫಾರ್ ಬಿಗರ್ ಅಮೌಂಟ್.
In fact, she was unaware about the terms of the settlement.
ಈ ತರ ಆದ್ರೆ ಎಲ್ಲದನ್ನು ಆಗದಾಗ್ಬಿಡ್ತಾರೆ. ಎನಿವೆ ನೋಟಿಸ್ ಮಾಡಿ. Emergent notice to the respondents. The pendency of this petition will not alter the rights crystallized in favor of the respondents pursuant to the impugned proceedings. Next. The others are not served still. All are served.
Yesterday, Madam Lord referred judgment of.
That is not applicable.
That is not applicable. Sir, Hindu law is. Sir.
We will hear it, madam. In name ಹಾಕಬೇಕಷ್ಟೇ ತಾನೆ.
Our ಹೆಸರು ಹಾಕಬೇಕಂತ.
We will hear it at leisure. Yes, in madam.
Sir, I have submission, sir. Respond number 1. Sir, I have the submission.
And she's divorced.
That's it. We'll hear it. We'll fix a date. List the matter on Saturday, madam. 25th. List the matter on 25th January.
Please.
2020. Objections ಏನಾದ್ರು ಹಾಕಿದ್ರೆ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ.
Please.
Objections, if any, by the first respondent, by the second respondent. By then. Yes. Next. Regularization.
Those everyone's asked an order for regularization. All statutory benefits are not given, and I am eligible as of 2007 onwards. The notification is of the year 2014.
So identical relief is granted to others.
Please, ma'am.
Yes, Lord.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ?
Respond number 2. I represent respond number 2. We will file a statement of objections on 2 days.
You want to file statement of objections? You want to file statement of objections?
2 in 3 days time.
Learned counsel, second respondent seeks
Phone number.
week's time to file statement of objections. List matter on date for it. 2 weeks ago. Objections, if any, by then. Yes.
Here, the petitioner, the petition is impugning the order passed by the learned district judge, granting meager compensation for utilization of the petitioner's land by the respondent, for laying of high tension line, and as well as utilizing the portion of land.
Serve on KPTC. Yaru Kamte avara?
Yes, sir.
Learned counsel BS Kamte is directed to accept notice for the respondent KPTC. Petitioner to serve set of papers upon the aforesaid counsel. List 17.
Please.
Yes. Next. Who has to forward pension papers? ಗೊತ್ತಾಯ್ತು. Pension papers ಯಾರು ಕಳಿಸ್ಬೇಕು?
2 and respond number 2 plus 3 and 4.
1 minute. Which college, sir? 3 and 4 have to send the papers to
Respond
number 2. So without hearing them, we cannot pass any order. You serve on the institution.
Please.
1 and 2 HCGP, 3 and 4 be served by way of hand summons and an acknowledgement to the defect be placed before this court. List the matter on 17.
Please.
Yes.
In this case,
KT.
work, ನಾನು only representation ಅಷ್ಟೇ ಚಾಲೆಂಜ್
Huh?
representation ಕೊಟ್ಟಿದ್ದೆ after service.
ನಾ ಏನ್ ರಿಲೀಫ್ ಕೊಡ್ಬೇಕಂದ್ರೂ KT. The petitioner is before this court seeking the following prayer. The petitioner is admittedly The petitioner is admittedly a police constable working in the home department of the state government and is a government servant. A writ petition venting out a grievance or considering the grievance of a government servant in petition under Article 226 without, at the first instance, the petitioner approaching the tribunal would run foul of the judgment of the 7-judge bench of the apex court in the case of L. Chandra Kumar versus so-and-so, AIR 1997-1125, which is subsequently followed in reiteration of the judgment of the apex court in the case of Ramesh Kumar versus so-and-so, 2010 4 SCC, page 454. In the light of the aforesaid judgments, entertaining the petition of a government servant to vent out any kind of grievance, unless exceptional circumstances exist, is not a course that is open to this court. As the 7-judge bench of the apex court clearly holds that the tribunal is the court of the first instance, and therefore the petitioner will have to approach the tribunal at the first instance. In that light, the petition stands disposed, reserving liberty to the petitioner to avail of the remedy as observed here in the law.
delay
ಯಾವಾಗಿಂದ ಇದೆ ಇಲ್ಲಿ? ಆರ್ಡರ್ ಯಾವತ್ತಿಂದ?
ಅದೇ 11
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ತಾನೇ ಕೇಳ್ತಿರೋದು. The delay, if any, during the pendency of the petition before this court would stand condemned. Yes.
is a delay is employee not
ಗೊತ್ತಾಯ್ತು, ಮಾಲ್ತಿದಾಸ್ ಪ್ರಕಾರ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು.
medical matter listed on 28th of
ನನ್ನ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿತ್ತು? ಸೇಮ್ ಟ್ಯಾಗ್ ಅದು ನೋಡ್ಕೊಳ್ಳೋದು ಯಾವ್ದು ಅಂತ. ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿತ್ತು? 68. ಅದು ಎಸ್. ನೆಕ್ಸ್ಟ್. Yesterday's matter. Yes, sir.
Serial number 9, Mala.
Yes, sir. Yes, sir. 9.
Please appear for the
ಇದು ಯಾರು ಕೊಟ್ಟಿರೋದು? ನಿಮ್ದಾ ಅವ್ರದಾ? This justice division bench judgment of this person Varale Sahibrda and Dixit Sahibrda ಯಾರು ಕೊಟ್ಟಿರೋದು?
Yes, ma'am.
Who is ನೀವು ಕೊಟ್ಟಿರೋದು?
They have referred. Along with their objection, they have.
Yes, is Anant Hegde ಅವ್ರದ್ದು?
None.
Yes, sir.
The first petitioner is a primary cooperative society, of which the remaining petitioners are the members of the committee. The term of the existing committee in the normal course would have expired on 5/1/2025.
5/1/25.
5/1/25.
All right. Yes.
Under Rule 13(d)(2),
ಕೊಡಿ ಮೇಡಮ್.
we are required to take steps for preparation of voter list, particularly the list of eligible and ineligible voters as provided under section 22A(4).
Yes.
Section 20.
it is in that regard, my lord, kindly see page 20, page 33.
Hmm.
A notice as required under Rule 13B2A was issued 195 days prior to the date of expiry of the term.
Page?
Page 30.
Ah. Yes.
It is dated 22/6/2024.
Yes.
This notice is served on all the members, concerned members, by Muddam, and their signatures are obtained on the society's
What is
book
the
maintained by the society.
under 13?
Mode of service under 13D2A is registered post. Is by registered post.
13B2A.
13D for dot.
B2A. All right. Yes. Name and address of the society.
Roman 2. 2 capital A Roman
13B2.
D2 capital A.
Hmm. Yes, sir.
In that small Roman 2.
Hmm.
The chief executive of every cooperative society shall send above prepared notice to all ineligible members 15 days prior to 6 months to the date of election of the board by registered post, and an opportunity shall be given to them for appearing. In the instant case, the said notice, though issued 195 days prior to the date of tentative date of election, was served by Muddam, of which records are available. This has been followed.
Receipt of this notice is not in dispute?
Receipt of this notice is not in dispute to the extent that now about 130 members have filed impleading application with affidavit saying we have been served with this notice.
Yes, sir.
Thereafter, the list of eligible and ineligible voters was forwarded to the authority for verification. No objections were received in that regard. Verification was also complete. In the meanwhile, regular list of voters with a defaulters list was also required to be published 50 days earlier, that is 2 months earlier to the election. When that was published, there was an objection filed by one member who is not by one member, that
Now, why you did not communicate?
including application, one member. The authority after the district election officer, after considering the matter, passed the order at Annexure A, page 20, 15/11/2024, directing that page 20.
Yes.
Directing to hold the election, allowing them to vote.
B, that is B, madam.
22.
Please.
Yes. Yes.
Under Annexure B22 on 15/11/2024, after passing Annexure A, he again passed another order saying one Mr. Kallappa Kali has raised objection as 13D2A notice is not issued as required under the rules, that is by RPAD. I direct that all these 13D2A should be redone.
That is the impugned order.
Please, Annexure A.
Now what is impugned is Annexure B is the first order, Annexure A
Is
is
the next
the
order.
order that directs redoing.
Both are of the same date.
Yes,
Same date. Annexure B was passed first, but later, in view of the objections raised by one Kale who came late,
Yes.
this order is passed saying you do it again afresh. 13(2)(a) should be done afresh. We pointed out at this stage that in respect of all the societies coming under the jurisdiction of this district, the Deputy Registrar of Cooperative Societies, the district election officer,
Yes.
respondent number 3, the notice under 13D2A has been served by Mudda. In none of the societies, it was sent by registered post. In all those societies, the very authority has permitted holding of election, allowing those members to vote. When this was sought to be done, we have filed an application for amendment, bringing on record the fact that for other societies, it has been permitted. That amendment application was allowed on the earlier date.
All right.
On facts, till today, neither the authorities nor the state has filed any objection disputing that matter on facts. That in respect of all other societies, the procedure followed was the service of notice by Mudda. We filed this writ petition pointing out this. We had the managing committee members of this society had some tiff with the authorities, in the sense they are supporters of a party which is not the ruling party in the state. Therefore, there were some other, in respect of some other matter, there were tussle. It is because of that we wanted to know that as the election is, if the order Annexure A is to be followed, election cannot be held prior to 5/1/2025. Therefore, there will arise a question of appointment of administrator under section 28A(5).
Yes.
For this, we pointed out under Annexure T, page 77, by a notification dated 5/6/2024,
P7.
Page 77.
page 77, Annexure T.
Yes.
This notification has a background in the sense, my lord, there were certain elections were due. By that time, the parliament election came up. Therefore, government issued a similar notification on an earlier occasion, stating that all the elections are postponed. There will be no appointment of 28A(5) administrator. Provisions of so and so are all granted exemption, and election should be held after the parliament election and code of conduct, etc. is over. That expired on 6/6/24. As a continuation of that notification, this notification dated 5/6/24 came to be issued. Again, granting exemption of the provisions, para 3 of the opening page, page 77. ಪರಿಶೀಲಿಸಲಾಗಿ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರ ಪ್ರಸ್ತಾವನೆಯಂತೆ ಸಹಕಾರ ಸಂಘಗಳು, ಸಹಕಾರ ಬ್ಯಾಂಕುಗಳು, ಫೆಡರಲ್, ಅಪೆಕ್ಸು ಚುನಾವಣೆಯನ್ನು ನಡೆಸಲು ನಿರ್ದೇಶನ ನೀಡುವುದು ಸೂಕ್ತವೆಂದು ಸರ್ಕಾರವು ತೀರ್ಮಾನಿಸಿ ಕರ್ನಾಟಕ ಅಧಿನಿಯಮ so and so 121 ಪ್ರಕಾರ ಚಲಾಯಿಸಿ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ 28A(4) and 5, that is appointment of administrator, 28B disqualification, 29F(4), 30, 31, 39A ಗಳಿಗೆ ವಿನಾಯಿತಿ ನೀಡಿ ಈ ಕೆಳಗಂಡಂತೆ ನಿರ್ದೇಶನ ನೀಡಿ ಆದೇಶಿಸಲಾಗಿದೆ. In this, my lord, your lordship may kindly see condition number 3, where it is said 13D(2A) notice should be issued afresh and it should start from the issuing of this notification.
What is your suggestion on this government order? Why are you relying on this now?
Please, I am relying on this for two reasons. Page 78, condition number 3.
All right.
Kindly see condition number 5.
Yes. Hali.
ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮ ಸ್ವಯಂಸೋದಂತೆ ಕ್ರಮವಿಟ್ಟು ಮತದಾರ ಪಟ್ಟಿ ತಯಾರಿಸುವ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಪದಾವಧಿಯು ಮುಕ್ತಾಯಗೊಂಡಲ್ಲಿ ಅಂತಹ ಸಹಕಾರ ಸಂಘಗಳು, ಬ್ಯಾಂಕುಗಳು ಮತ್ತು ಅಪೆಕ್ಸ್ ಹಾಲಿ ಇರುವ ಆಡಳಿತ ಮಂಡಳಿ ಹಾಗೂ ಪದಾಧಿಕಾರಿಗಳ ಅವಧಿಯು ಸದರಿ ಸಂಘಗಳಿಗೆ ಚುನಾವಣೆ ನಡೆದು ಹೊಸ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆಯಾಗುವವರೆಗೆ ಮುಂದುವರಿಯತಕ್ಕದ್ದು. Therefore, we filed a writ petition saying either on this very 13D(2A) notification, please hold the election before 5/1/25, or otherwise, please give us the benefit of condition 3 and 5 of the government notification.
The notification
So
is
that,
subsistence even today?
yes.
Yes. All right. Yes.
This is the contention. Even otherwise, we have pointed out, in respect of almost hundreds of societies, they have held the election following the same procedure of service of notice by Mudda.
Yes.
There was no reason to single out the petitioner society unless they want to displace the body. Particularly because one of the petitioner, that is petitioner number 2, is a member of the Milk Federation through this society as a representative of first petitioner society.
All right.
Therefore, we approached this court with the prayer to hold the election, issue a direction to hold the election immediately.
Yes.
I am for the
Interim stay was granted, but it did not, authorities, though order annexure A was stayed, authorities did not take steps for holding the election, to continue the election under as per annexure B. Therefore, we had to make that amendment application and also seek direction to issue the calendar of events, hold election as early as possible. Now that those dates have passed by, your lordship may kindly mold the relief.
So, in case
As-
I'm accepting the submission, what is the relief that should be granted, we will decide. Now, who is the contesting respondent?
I am the contesting respondent, my lord. I have filed I number 3 at my behest. Impugned order at annexure A has been passed, my lord.
All right.
I number 3 of 2024. I sought to implead myself as respondent number 7, my lord.
That if a pleading application is not allowed, we filed an objection for that.
We'll see. So, 1 minute. Yes, sir. You are for the state
Two submission are made.
Election authority.
election authority.
Kindly take section 20 of the Cooperative Society Act. That is provide for a voter of the votes of the members, the substantial rate of the members. The important provision is A subclass vote. It provides there is a statutory requirement, one should attend the general body. Out of 5, 2 general body is required to be attended.
Right.
Then next he should take the minimum service, subclass 5. Only if take the minimum service, if they attended the 2 general body meetings, and if they take the minimum service, they are eligible to vote.
We are not on whether they are eligible or ineligible. Now, notice to be issued to the ineligible voters, there is a provision. Notice is issued by Muddam. You have received the notice is what is said. Now, Rule 13(2)(v)(2) would say that it should be by registered post. Whether Muddam is to be accepted or not is to be decided as there.
Only 13(2). There was amendment to 13(2)(a). 13(2)(a) was amended. It was incorporated in the year 2022.
What is the amendment?
This amendment is 2A itself has been incorporated by amendment in the year 2020 by way of amendment.
That's 2020.
The reason is that the person should get an opportunity before 6 months, whether he has attended the interview or not. Sorry, the meeting. So that given opportunity for the member to defend himself before the society and election office.
Correct.
So therefore, the legislature has intended that the register post is a mandatory. See, because one cannot say that whether signature cannot be considered the service of notice, because that anybody can force their signature and contended that notice has been served. So to avoid all this complication, out of experience, legislature, the amendment was suggested. The 2A was being added, which is only to answer the substantial right of the member under 4.
All right, that is also.
So this provision is held as mandatory registrable court, it's no longer vested in the government. So therefore, not a provisional voter list was been issued.
No, in that in those judgments, it is held that the manner in which it should be served is mandatory or service is mandatory.
Mode of service is not.
The 13(2)(a) is mandatory. There is no distinction that whether it is by way of this thing.
My question is simple. The knowledge of the notice is important. Prima facie. How it comes to you is definitely flexible. Is what I'm. Prima facie, what is running in my mind. Now, notice you have received. Muddam receive agida.
Even not all, they are disputing. The contestant is disputing. It is in the case of 200 members. If the society consists of 10,000 members, if they get 400 signature of 5,000 members.
No,
suppose
a sweeping generalization cannot be made.
My most acceptable submission is that. So when the legislature is intended.
When the act performs a particular duty to be performed, but it has to be done that way. That is settled principle.
They cannot substitute that. It is always service. They have the knowledge of the facts. All those things, my most acceptable submission is that. They cannot contend with the dishonorable court.
Right. Now, notice is not served. It has to the procedure has to be redone.
Please.
Then that notification comes into effect.
That is submitted.
5/6/2024, the current senior counsel relied on.
That notification was issued when the election process was already.
Correct. Parliament elections.
Parliamentary elections, those elections are interrupted because of the fault on the part of the government, not only the election. But this is not a case. It's a subsequent event where the society has defaulted, not conducting the election in proper manner. Their default is not complying the procedure. They are not entitled to get a benefit under that notification. That is before that. When the notification was issued, the election process had not even begin. Therefore, those annexed team, my most reputable submission is that was only available, those election process has already begun and interrupted because of the number of parliament elections. So therefore, they cannot take the shelter under annexed team. The similar situation in the division bench of this court, where the
Which one?
in the IFR objection to IMR, along with the objection
By the election officer?
In the state objection. I filed on the first judgment.
First just MIR owner.
It says D2 as a mandatory.
All right.
Therefore, the appointment of the administrator after the expiry of the tenure has been applied.
All right.
That was confirmed by the Honorable Division Bench.
All right.
It annexed page 36, which says it is a mandatory one. So they confirmed the order of Leonard Singh judge.
All right.
The history of 13 and everything has been covered in this. So this court says 13 DPA is mandatory. So and we upheld the appointment of the administrator. There also the tenure was expired. The next judgment which I have read, document number 3, which is a judgment which says once the tenure of the board has been expired, so that cannot be extended.
Justice Nataraj.
Please. So this is where we have questioned the validity of the, it can be extended because of any reason if the elections are not held, they are entitled. This was been confirmed by the division bench, document number 4, page 176.
Page
176. So which is confirmed by the judgment of this. So therefore, madam, 13 DPA is mandatory. The provisional order which was been issued call for the objection.
Now you want an administrator to be appointed here.
The matter is
that is the intention.
This matter is pending before transport and their tenure is expired.
Tenure is expired.
Tenure is expired. This court has been interpreted. There is a question of extending the tenure in respect of the cooperative society subject. It is not the status of the cooperative societies and companies are different. So therefore, by interpreting all provisions of the Act and constitutional provisions, this court has interpreted. There is a question of extending the tenure of the cooperative society. My lord, I can understand. If the elections are interrupted because of the fault of the state.
So there is no interruption of the kind that led to issuance of the notification here.
Please.
It is your submission. It is plain and simple that they have defaulted in elections. So that is over. It should not be extended. Not be extended. Administrator should be appointed. Administrator should hold the elections. That is all your submission. Yes. You are.
One other aspect, my lord, my learned friend maybe now itself will be asked whether actually they dispute the fact that in respect of all other societies, this procedure has been
negative equality.
That's all. I am not asking you whether are you disputing that question. Concept of negative equality is all wrongs cannot make one right. Yes.
The reason is that it is a members specific. If the members have no objection, if the members are not questioned,
so only members have objected.
Yes, my lord. Yes, my lord. Otherwise, state is not interested in that.
Yes, my lord. Yes, my lord. In this case, my lord, it's an admitted fact that no notice is issued. And the clause will be kindly seen, my lord.
No RPAD is taken
issued.
So,
now, clause 3, 2A, subclause Roman 2 says, shall, that may be kindly seen, my lord. The chief executive officer, every cooperative society shall send a notice, above prepared notice, to all the ineligible members. That is admittedly not done. Therefore, impugned order at annexure A is justified. Now, regarding the appointment of the administrator is concerned, my lord, they admittedly on 5/1/2025, term is expired. Now we are on 7/1/2025. Can they take shelter under page 77, annexure T? I will take your lordship. Those two paragraphs are skipped.
No, the state is
annexure T, page 77.
Yes, sir.
77.
No, it was issued in the wake of parliament elections.
Yes, but that was expired in long back. After that, they all commenced this. They cannot take benefit of this. The counting was held on 4/6 and the erasure declared. Therefore, anything happened during that tenure is applicable. Therefore, 5/6/2024, the annexure T is not applicable or annual to the benefit of the petitioners. Straight away, there is a disqualification now for non-conducting the election within the statutory period. Therefore, there is a violation of the law regarding the issuance of the notice, not holding the election within time, and they will incur disqualification. Therefore, under their guidance, they cannot say that we will conduct the election. No. A neutral person, administrator can be appointed. He may be directed to conduct the election in accordance with law, my lords.
All right. Ashra? Yes, sir. Anything in reply?
Please, my learned friend referred to judgments produced as documents 1 to 4, my lord.
Yes.
In all those judgments, your lordship may kindly see all were prior to 6/3/2024 and 21/3/2024.
What is your suggestion on that?
Suggestion on that is kindly see annexure T. Kindly see annexure T.
Page 77.
Please, page 77. Reference number 1. Sarkarada Adesha dated 21/3/2024. This was the first notification under which government, in exercise of power under section 121, extended the term of all the cooperative societies.
When did the term of the society expire?
This is on 5/1/2025, 2 days before.
Year, day before
Sunday.
yesterday. 5/1/2025.
Yes, madam.
ಇದೆ ಅಡ್ಡ ಏನಿಲ್ಲ 6 months ಮುಂಚೆ ಯಾವ ಎಲೆಕ್ಷನ್ ಇತ್ತು ಅಡ್ಡ ನಥಿಂಗ್
ಯಾವ election?
Then
ಯಾವ election?
ಒಂದು ನಿಮಿಷ 21/3/2024 ಗೆ first of the notification is issued extending the term in exercise of power under section 121. I am not asking the court to exercise its inherent power to extend the term so that in contravention of division bench judgment. On the other hand, in all those cases, as there was no such notification during that period, court said court will not extend the term of the elected body. It will go to 28A5, whatever happens. First of the order was on 21/3/2024. Similar order extending the term of all the boards which would have expired on that day. That was again continued by the present notification dated 5/6/2024, saying not only those which had this thing, even those where election was to be prepared, etc., during that period, all those which will expire would be continued. Kindly see the wordings.
no, this is reiteration of what was issued during COVID period. Saying that those
Not COVID time nallu ಒಂದು ಮಾಡಿದ್ರು.
ಆಗಿಲ್ಲ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರು ಅದೇ ತರ ಇದು.
My lords, clause 1 and 2 will be condition will be kindly seen, my lord. That is not read, my lord. Clause 1 and 2, page 78. Very important, my lord.
My learned friend either may
ವಿಡಿಯೋ ಅದು ಕಂಟಿನ್ಯೂ ಆಗದು. That term will continue.
ಇವ್ರದ್ದು ಆವಾಗ comments ಆಗಿಲ್ಲ ಅವಾಗೆ.
Why this notification perhaps was issued, if my understanding is correct, is the election in these societies had commenced. Intervening parliament elections come in.
Yes, my lord.
Parliament elections ಮುಗಿಯೋವರೆಗೂ ಇದು ಕಂಟಿನ್ಯೂ ಆಗಬೇಕು.
ಹೌದು.
That's all.
ಈ ಕೇಸ್ನಲ್ಲಿ ಇಲೆಕ್ಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ, ಕಾಮೆನ್ಸ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಇವ್ರದ್ದು. ಕ್ಲಾಸ್ 1 and 2
ಹಿಂದೆನೂ ಅಡ್ಡ ಏನಿತ್ತು ಏನೂ ಇರಲಿಲ್ಲ.
ಏನು ಇರ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ ಮಾಡ್ಲಿಕ್ಕೆ. ಕ್ಲಾಸ್ 1 ಮತ್ತೆ 2 ಸ್ವಲ್ಪ ಓದ್ಬಿಡ್ತೇನೆ ಸರ್. ಕ್ಲಾಸ್ 1 and 2, my lord. It's clear, my lord. Page 78.
Venkatesh sir, I've read it. Yes.
Yes, my lord.
Yes.
ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಟವಾದಂತಹ ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಟಣೆ ಆಗಿಲ್ಲ ಇಲ್ಲಿ. Yes, my lord. 1 and 2, learned senior counsel is not reading clause 1 and 2. That is the condition precedent.
That's all right. Yes.
Yes.
ಅಲ್ಲಿ ಕ್ಯಾಲೆಂಡರ್ ಇವೆಂಟ್ಸ್ ಇಶ್ಯೂ ಆಗಿತ್ತು ಆಲ್ರೆಡಿ.
ಹೌದಾ? ಇದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ. ಆಗಿದ್ದ ಕೇಸ್ನಲ್ಲಿ ಮಾತ್ರ ಅಪ್ಲಿಕೇಬಲ್ ದಿಸ್ ನೋಟಿಫಿಕೇಶನ್.
The so-called learned friend has not prohibited anybody from reading clause 1 and 2, nor has he prevented the judge from reading clause 1 and 2.
I have seen it. There is no deliberate attempt here, sir. Venkatesh sir.
Not question of deliberate attempt. On the other hand, my case is altogether on a different footing. What I am pointing out is, in all the cases where societies had sought for extension, that was not during the period when such notification, at least for some societies, was available.
Correct.
At that time, the court said, no, court will not extend the period.
Yes, what you're telling is whether societies had issued calendar of events or not. this notification, benefit of this notification is given to every society where elections are not held.
Even otherwise, it may have to be extended to the petitioner society for this reason. What I am pointing out is, in respect of all other society in this district, this very election officer in whose these societies come.
So, but would I not be passing some order if I accept your submission contrary to the division bench judgment?
Division, that is why I pointed out, even division bench judgment, your lordship may kindly see. That was also prior to 21/3/24.
That's distinguishing factor is that.
Yes, my lord. If there were to be a notification at that point of time applicable to majority of the societies.
My submission is that this notification is not at all applicable to petitioner society, number one, and this notification is applicable subject to rider contain the clause 1 and 2, that rider is not complied by the petitioner, my lord.
Page 1.
Subject to clause 1 and 2, clause 3 can be read, my lord.
Either my learned friend argues the matter or he will allow me to complete.
Patil sir, now
Please.
if all right, they are prior to 21/3/24, all that is fine, but there is a statute in place. The statute prescribes mode of service.
Yes.
Any amount of judgments prior or after, will it take away the rigor of the statute?
No.
If an act
That is where I am relying on the factual aspect. Why this particular society should be singled out in respect of every one of the society.
Why did you
Please get a report.
in respect of every one of the societies? If the rule is
Please get a report.
no,
I will answer.
Gangadhar, rule is there. Rule is in subsistence. Rule had to be followed by every society.
Please.
The Learned Senior Counsel says, and you admit that rule has been violated in every case.
I'm not saying that whether it has been followed or not, we are not disputing. There is no complaint.
Objections.
We are not agreeing.
There are no objections to it. So you accept that however it is, mode of service has happened. There.
There is no question. Since there is no, that is the reason I request kindly take case 60. The provisional voter list, last paragraph of the provisional voter list, where while issuing the provisional voter list, the district election officer, concerned election officer, call the objections from the members. Anumodan Pragare. So therefore, in case of the publication of this provisional voter list, members give a complaint to the district election officer
That they have not received the
they
list.
are not received. Therefore, you are exercising.
No. Not by the members who have not received. It was by one of the impleading applicant who is not about the members.
So therefore, his name was not included in the voter list.
Let us be very clear on factual aspect.
So therefore, see, in the election dispute matter, unless the complaints are received,
So the law is clear. The senior counsel says it is only on facts that law should not be made applicable because state has permitted every
my
society.
most approval is sufficient. There is no objection in that aspect. It is an election matter. Only if the objection comes, we receive it. Because the burden is on the society. That is my request. 2A, the entire burden is on the society. The secretary has to place the material before the deputy registrar. When we see the language of the 2A, entire burden is on the society. Because who is attended the meeting, who has not attended the meeting, he should place before the deputy registrar.
All right. Yes. Anything else?
My lords, that least may be kindly seen, my lord, that we have disputing the signature, my lords, number one. We are telling it's a forged signature and it does not contain the date, anything, my lord. That may be kindly seen, my lord.
Page.
At page, annexure G, page 31. No date, nothing. Means in my lord, no date anywhere. Nothing. All pages may be kindly seen, even conclude last page, my lords. Which date, who have signed, nothing. till page 41, from 31 to 41. This is number one. Number two, my lords, regarding under what provision this was done, they are having no answer for it. Substituted service.
Reserved.
Yes, ma'am.
Annexure G starts from page 30, which has the date.
No, there's only it's an appendage to annexure.
Yes, my lord.
Yes, ma'am. There is nothing is there, my lord. Who have signed on what date, where, which place, nothing. And even my signature is forged.
Around 5 to 6% of the dispute pertain to the voting rights.
And my lord, that one affidavits have been filed by various persons stating that they have not signed. That may be considered, my lord. All the persons who have not signed and stating that it was forged, they have filed the affidavit before this honorable court, my lord. That may be kindly considered, my lord.
There is no judgment given by you saying that 13 to AD2 Roman 2 is not mandatory.
It is mandatory. All
No,
judgments,
all the judgments
all
say it is
judgments
mandatory.
continuously follow the division.
All these things are mandatory. It shall and it is mandatory.
The directly considered is only the point of 195 days. In none of the judgments with regard to service, how it was done, whether a person who has signed and received it can say that I will not, this thing, all those things did not come up. What came up was timeline for
No, my lord.
compliance.
In another Lakshmi Devi judgment, my lord. In Lakshmi Devi judgment, I will pass on, my lord.
Sir, wait. Senior counsel is submitting. Agree. Yes, sir.
In the first matter, notice was issued was of 110 days. The authority did not accept it. Court said, yes, that procedure is not followed.
180 days is mandatory.
195 days is mandatory.
Mandatory to be issued. That was affirmed
Yes.
by the division bench.
That was affirmed by the division
They
bench.
were going to again on the same principle. But 13, whether mode of service is not interpreted.
Not
Only two. If there is a 10,000 members,
ಅರ್ಥ ಆಯ್ತು.
only enough.
ಗೊತ್ತಾಯ್ತು. ಇದು ಬರೀ ದೌರ್ಜನ್ಯದ್ದು. Law is applicable to any number of members in the society.
ಆ ಡೇಟ್ ತಗೊಂಡ್ರು 186 ದಿವಸ ಆಗ್ತದೆ ಸ್ವಾಮಿ. 195 ಆಗುದಿಲ್ಲ.
Yes.
Only India is
186 days.
the mode of service cannot be issued with the signed summons or signing. It cannot be issued to the register court. That is the only way.
We'll see.
Please.
And all implementing applications ಯಾರ್ಯಾರ್ದು?
3, 4, 5, 6, and 7.
We will allow all the implementing applications.
Yes, my lord.
Any objection, madam?
Only one complainant is my
Well,
lord.
at his behest, everything has happened. How did you not make him a part?
Action is taken.
No, it's,
Action is initiated by the officer on behalf of his complaint. Now he is not a
So,
necessary party.
he is in the nature of a complainant. Anyway, we'll allow that application.
And one, and there, I have filed a memos, 2 memos, stating that 165 members filed a personal affidavit. They are ready for election.
They are ready.
Yes, 165 members, personal affidavit is filed along with
Now
memos.
we are posed with.
they have, no.
The facts
They have
are-
accepted the service of notice.
Yes,
They have
yes.
stated that they have received the notice.
And in fact, there is notice.
Monday we'll give it. Yes. Third result.
There cannot be a estoppel against the statute, my lord. Statute when say mandatory, by
Yeah.
giving affidavit, they can say we are conceding it, my lord.
Sir, don't get into rudimentary things. Yes.
Yes, ma'am.
Implementing is allowed ಇಲ್ಲ. ಅಲ್ಲ implementing 7th respondent ಅವರು allow ಮಾಡಲೇಬೇಕು. He is the complainant. IA 7 is it? What's your IA?
I 3 of 24, my lord.
For the reasons indicated in
In view of the
the.
Yashwant Gaur Supreme Court judgment, my lord, the complainant is not necessary party. He can see his prayer not in the present petitioner's case, my lord. Para 53 is very much clear about that.
ಕೊಡಿ.
2012 part 4 SCC 406.
No, no, yes. They, all right, we have permitted him to argue. We'll consider it. Yes.
In impugned order only my name is there, my lord.
Don't worry. Yes.
Serial number 10, my lords, I may be permitted to argue for the advocate for petitioner.
Work order issue agidiyalla already.
Illilla, my lords, kindly see page number 31. The work orders cannot be issued
Why?
for the total quantity of 10,000 kilograms of polythene sheets. Page number, it will be, my lords, as and when it is required from time to time, they would be issuing. Page number 31.
Where is the work
The-
order? You have issued for all 10,000? Polythene, 1 lakh. Total number ಏನಿದ್ರಲ್ಲಿ? On 8/10/2024, long before this, yes.
My lord, this is as and when this is a case where, my lords, the polythene bags are required for the purpose of seedlings for the forest department.
What is the illegality?
The illegality is this, my lords, that I am a supplier, not a manufacturing industry.
All right.
Now, the notification also specifically mentions that the eligible tenderers are those who are either manufacturing industries or suppliers.
Your
Now, the order impugned says.
1 minute, sir. Your technical bid is rejected. Against that, you prefer an appeal. Appeal is rejected.
No, there is no appeal. As I'm instructed to submit, I have only given a complaint or a representation recently saying that you have committed these illegalities. You cannot completely say that no supplier is eligible at all. It's a case of, my lords, a violation of the freedom of trade, not a mere question of an error in appreciation of the notification. Kindly see the notification itself at page 31, invitation for tender. It says it is hereby notified calling attention of the desirous tenderers bidders of manufacturing or supplying industries. For
You are
supply of
a supply industry?
I am only a supplier, my lords. I am only a supplier.
For the
I buy
supply.
it from a manufacturing industry and I supply.
All right. Now, who has been awarded the contract or manufacturing industry?
Please.
Not only that,
Why did you reject this technical bid? On what ground? That is a supply industry?
Kind permission, yes.
Really?
Lord, may I take the lordships at page number 16. The reasons for which his applications have been rejected have been on various about 9 conditions he has violated. On this basis, my lord, the technical bid of the petition came to be rejected. Knowing fully that the application has been rejected, he files an appeal before the appellate authority.
All right.
Wherein, my lord, appellate authority also thereafter passes an order rejecting his. That orders are not questioned in the present. Suppressing those facts, he filed a writ petition before this one.
The technical bid rejection mele there is no appeal.
Lord, the section 16.
Section 16 comes into effect on compliance with section 13.
Lord, for that
Section 13, an work order is to be issued to someone, only then section 16 comes.
That has been already.
Now work order is not issued. It was in the interregnum technical bid is
Work order
rejected.
is, may I take it page 27?
The 8/10/24.
How? 27/9/24.
Work order is issued.
Yes, yes. At page 27, order is passed.
When was the appeal filed?
Appeal was filed, my lord, on 5/9/24.
5/9.
Yes, no. Rejection order was on 24/9.
Sir, work order is issued on 27/9. How can appeal be filed before that?
My lord, 26/8. Appeal is filed on 26/8.
Even before that.
Yes.
Work order is 27/9/24.
Yes.
So that's not an appeal.
Allah, yakandre one submission. May I?
Section 13 OD, it is only against the issuance of work order, correct?
Yes, yes.
Not every order you can file an appeal.
But under section 6, please.
Order antane ide alli. Section 13 ನೋಡಿ.
Please. Acceptance of tender, section 13.
All right.
Yes.
Section 13 ಅಲ್ಲಿ section 16 ಗೆ ಹೋಗಿ.
Please. appeal any tender executed by an order passed by the tender accepting authority.
Yes, correct.
So, my lord, pursuant to which now the accepting authority
Sir,
has
work orders are issued by the tender accepting authority
Yes.
after he prefers an appeal, complaint,
Yes.
representation, whatever
Yes,
it is.
sir.
After the work orders, if he has to challenge, he has to prefer an appeal
Yes.
under section 16.
60, yes.
That does not stop this court to look into the illegality in the issuance of tender
Yes.
or work order.
Yes.
That is there.
These are the conditions which he has violated as far as
That we'll see.
that he
You
has-
don't challenge the orders.
My lords, I am basically not completely ousted from the competition. If I may use a phrase from the Honorable Supreme Court's judgment, where, my lords, the Supreme Court uses this word, competition is necessary for maintaining a free market, so that Adam Smith's concept of invisible hands operate unhindered in the background. This is a case where that is violated. Kindly see, my lords, my friend has pointed out page number 27. This is another ground.
Who are you ousted? You are, marred of 9 illegalities as was
No,
said.
no. I'll point out that much. All the 9 will only relate to saying that I have not produced some document relating to me being a manufacturing industry. I cannot, my lords, comply any of the conditions if they say that I have to show something relating to a manufacturing industry. I will read number 1. Kiran Bhatt, ST Agencies, Siddhapuri ಅವರು ST Agencies ಎಂದು ಮುದ್ರಣ ಇರುವ LDP ಪಾಲಿಬ್ಯಾಗ್ಸ್ ಗಳನ್ನು ಡ್ರಾಪ್ ಟೆಸ್ಟ್ ಸಲ್ಲಿಸಿದ್ದು ST ಏಜೆನ್ಸೀಸ್ ಎಂಬುದು ಒಂದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಎನ್ನುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ದೆನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಅಗೇನ್ 2 ಕಂಡೀಷನ್ ನಂಬರ್ 1 ರಂತೆ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಆದ ಸುಪ್ರಿಯಾ ಪ್ಯಾಕರ್ಸ್ ಬೆಂಗಳೂರು ಇರುವ ಟೆಂಡರ್ ಸಲ್ಲಿಸಿರುವುದು ಅವರ ಕಂಪನಿಯಲ್ಲಿ ಇರುವ ಸ್ಥಾನಮಾನದ ಬಗ್ಗೆ ಯಾವುದೇ ದೃಢೀಕರಣವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. 3 ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಸರಬರಾಜು ಮಾಡಿದ ಸಂಬಂಧಿಸಿದ ಸರಕು ಬಿಲ್ ಕೊಟ್ಟಿಲ್ಲ. 4 ಅಗೇನ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ. 5 ಕಂಡೀಷನ್ ನಂಬರ್ 4, 5 ದಂತೆ ಬ್ಯಾಗ್ ಗಳನ್ನು ಡ್ರಾಪ್ ಟೆಸ್ಟ್ ಗಾಗಿ ಕೊಟ್ಟಿಲ್ಲ. ಒಂದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಎನ್ನುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆಲ್ ದ 9 ಓನ್ಲಿ ರಿಲೇಟ್ ಟು ಮೀ, showing that I need to show something relating to be a manufacturing industry. Now, my lords, kindly see page number 27 once again. This is another ground, my lords, where I am submitting. This is cartelization. Kindly see the amounts which all the 5 who have now been given the tender. For 5 into 8 240 gauge, 212.40 per kg of the first tenderer who is allotted this. Second also 212.4. Third one 212.4. Fourth one 212.4. Every number your lordships will see there is exactly the same, not even a paisa of a difference. This is completely, my lords, cartelization, which is prohibited under section 3 of the Competition Act. That's where I quoted, my lords, this judgment, the except from this judgment of the Honorable Supreme Court. Where
the contentions of the senior counsel is that the tender notification which was issued was for both manufacturer/supplier.
Yes.
The intention of issuing of the work orders to the manufacturer is in order to, since the document the quantity which we have to receive for the purpose of plantation.
They would have supplied whatever quantity wanted.
Manufacturer straight away manufacture whatever the.
Why did you notify
quantity.
that manufacturer/supply industries?
Manufacturer/supply.
Why? Either, sir, manufacturer/supply, and either of them can participate.
Yes. We are not disputing insofar as the participants is concerned.
But for what purpose they participate? For nothing, is it?
No, but the reasons for which his tender notification has been rejected, we have specifically stated in our technical bit itself.
Come to those reasons.
Yes, sir.
Come to those reasons.
Yes, sir.
Where is any reason that pertains to his disqualification? Tell me. Every reason is that it relates to manufacturing.
Yes.
Is that correct or not?
Yes.
ಹೌದಾ?
ಹೌದು.
ಮತ್ತೆ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ ಟೆಂಡರ್?
ಅಲ್ಲ ಅದಕ್ಕೆ ಸ್ಲಾಶ್ ಅಂತ ಹಾಕಿದ್ರೆ
ಸ್ಲಾಶ್ ಅಂತ ಹಾಕಿದ್ರೆ
ಅಲ್ಲ
ಏನಲ್ಲ?
the purpose of
Slash, what is the purport of slash?
whether accommodate for both.
Seriously?
Yes.
Then how did you, technical bit, how was it rejected on the ground that you are not a manufacturing industry? You have not produced any document to show that you are not a manufacturing industry.
For that reason,
ಅದೇ ಮಾಡಿರೋದು.
ಅಲ್ಲಲ್ಲ. The reasons for passing this technical bid or rejection is, my lord, we are ongoing to the document verifications.
He cannot produce any manufacturing
Yes,
industry
that cannot be,
document.
that
He is
cannot
not.
be.
He is a supplier.
Yes, yes, yes.
You have notified suppliers also to be eligible. Difficult.
On technical eligibility grounds, my lord, then they have to, for now, rightly or wrongly, an order is passed. Subsequently, wherein, my lord, he has approached the appellate authority and appellate authority has rejected his claim.
There is no appeal filed by him. It's a complaint or a representation.
Allah,
Because work order is issued on 27/9.
Yes, yes.
The appeal or the whatever complaint he has preferred was 1 month before that.
That is on 26/8/24.
One thing ಆದ್ಮೇಲೆ work order issue ಮಾಡೋ ಕಡೆ
Order was passed on 24/9.
correct sir. Order was passed on 24/9.
Yes.
Work order is issued on 27/9.
Yes.
How can he file an appeal against the issuance of work order 1 month prior to the issuance of work order? As simple as that.
On technical now, already they have commenced the work.
ಏನ್ ವರ್ಕ್ ಇದು?
Allah,
Procurement of bags and manufacturing of bags.
Particular period, my lord, plantation.
ಈಗ the whole thing you have not awarded still.
No.
As and when requirement arises.
This period for only for a period of 6 months.
Correct, short term tender.
For that reason, my lord, already now they are distributing and we have collected for the last 2 months and we
They
have
will
paid
also
we have paid the payments to the distributors. Now the persons who have been allotted. Now to redo the entire process, my lord, and again it hurdles.
True, but you can't escape law.
That is true, man.
Okay. Manufacturing and slash supplier and supplier ನಾಚನೆ ಹಾಕ್ಬಿಟ್ರೆ
ಅವ್ರು ಆಚೆ ಇಟ್ಟಿಲ್ಲ ನಾವು. But
ಆಚೆ ಇಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಒಳಗಡೆ ಎಲ್ಲಿ ಕರ್ಕೊಂಡಿದ್ದೀರಾ?
The intention was to get the benefit in
ಇದರಲ್ಲೆಲ್ಲ
larger extent, larger quantity.
ಇದರಲ್ಲೆಲ್ಲ intentions are something else.
No, that is not
So
that is not
the tender.
In fact, page number 88 would show that the maximum number of tenders that can be allotted to one person is only 4 circles. They have allotted 13 circles to the private respondents.
Private respondents are served?
Yes.
Served unrepresented.
third on the
And page number 34, clause D of para 1 will say that the period of contract may be extended from time to time as and when required till the next arrangement on a mutual consent is made.
Correct. 6 months it will go on.
But the period for that supply of that package.
It's all right, but it should be in accordance with law. I'll dictate it by the end of the day.
Please.
By the end of the day, I'll dictate it. Yes.
Grateful.
Yes. Next.
Mandamus against case BC, PCI and BBA.
Where have you produced any document to show that they are not enrolled, they are not advocates? ಏನilla, petition ಏನಿಲ್ಲ.
This is a subsequent development.
What subsequent? When you move the matter, yesterday you moved the matter saying that they are practicing without qualification.
Please,
Where are the documents?
so this is a document. I'll furnish it with along with your memo.
If you keep it, then how would I even read it? Move ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿದೆ advocates. I told, if you have concrete evidence, then move it. Otherwise, if an advocate is enrolled correctly, I can't by a stroke of pen stop it.
No, sir. This is an resolution passed by BBA, Belgavi Bar Association, wherein documents were sought from the respondent number 11. And she has threatened the members of the bar in a meeting that she did not produce any document. On the other hand, she would commit suicide by writing names of the members, which is recorded in the resolution. I'll file it with a memo.
File it to the memo. Only notice one AGA, Bar Council of India, Labeka.
Representations were made to them.
Bar Council of Maharashtra and Goa. Why, sir?
She claims that she has completed her education in Maharashtra after having failed in Karnataka.
That we'll see. We'll notify them. Emergent notice 1 AGA 2, 3, 4, 5.
YK Dute appears for 2.
Yaru?
YK Dute, DIBTE.
ಅದು ಬರ್ಕೊಳ್ಳಿ 2ಗೆ ಅವರು 3 KSBC
Archana Magdum.
ಕೌನ್ಸಿಲ್ ಶ್ರೀಮತಿ ಅರ್ಚನಾ ಮಗ್ದುಮ್ 4
notices to go.
4 emergent notice ಇಲ್ಲ ಶ್ರೀಧರ್ ಪ್ರಭು ಅಪಿಯರ್ಸ್ ಕೆ ಶ್ರೀಧರ್ ಪ್ರಭು 4 5 emergent notice ಆಮೇಲೆ 6 7 8 1 6 7 8 state
Even 9 emergent.
1 6 7 8 and 9 state again 10 and 11. Who is the person? This 11 is
11
self claimed advocate.
She claims to be an advocate.
You have described her to be self claimed advocate.
Please, Your Lordship, because there is a mark sheet issued by respondent number 10, wherein they say she has failed her exams.
All right. By interim order, we can't stop anything.
Please, Your Lordship.
Let's see. Let the records come.
Please, Your Lordship.
Emergent notice returnable by second week of February in date. Yes, 10/2/2025. Yes,
There
next.
is also a similar matter in writ petition 106394.
Yours is here.
No, Your Lordship, it may kindly be connected with that matter.
The notice is already issued in the.
Notice is issued.
Tag the petition along with the number barcode. Next. Freedom fighters pension in. Take notice. Learned AGA is directed to accept notice for the respondents. Yes.
May I seek for earlier date? She is an 89 years old.
89 years.
89 years.
Who?
The petitioner in this freedom fighters pension case.
Isn't him then?
Please, Your Lordship.
All right. ಅದಕ್ಕೊಂದು ಡೇಟ್ ಕೊಡಿ wait 23rd January.
Please,
Yes. Next. Office objections overruled. Huh? Alternate remedy ಇದೆಯಾ ಅದರಲ್ಲಿ? ಹಾಕ್ಬಿಡಿ.
But I want
Interim relief.
annexure E.
Yes.
Based on that this implement order, they have directed the present CEO to initiate criminal action against this petitioner.
True, but you will have to seek remedy there only, sir. If I'm closing this on alternative remedy, how can I grant an order?
Because
I will see. The petitioner is before this court seeking the following prayer. The learned HCGP would submit that the petitioner has an alternative and efficacious remedy of filing an appeal under section 106H of Cooperative Societies Act. The learned counsel for the petitioner submits that the order dated 4/12/2024 stares at his liberty as direction is granted to initiate criminal proceedings, and if protective orders are not passed, criminal proceeding, the crime would be registered immediately on dismissal of the petition. In that light, I deem it appropriate to direct the respondent state not to take any precipitative action against the petitioner for a period of 2 weeks. For a period of 2 weeks, the petitioner is at liberty to avail of remedy of filing an appeal within the next 2 weeks from the date of receipt of the copy of this order. In the event the petitioner would not avail the remedy of filing an appeal within the next 2 weeks as observed here and above, the interim protection granted supra would automatically vanish. Ordered accordingly.
and period of limitation 60 days.
ಯಾವತ್ತು ಹಾಕಿದ್ರಿ? 16/12 ಹಾಕಿರೋದಾ? ಏನು ಲಿಮಿಟೇಷನ್ ಏನು ಬರುತ್ತೆ? ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು ಯಾವತ್ತು? 4/12. ಈ ಒಂದೇನು ಲಿಮಿಟೇಷನ್ ಇರುತ್ತೆ ಅಂತ. Next. Promotions granted or what?
Please, Lordship, in the subsequent note, I have filed one more application.
ಅಲ್ಲ ಪ್ರಮೋಷನ್ಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ವಿಲ್ ಮೇಕ್ ಇಟ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಆಫ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳಿ
ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು
ಸರ್, ನೋಟಿಸ್ ಮಾಡಿ.
Lordship, kindly note that.
Can I stay promotions, sir? Promotion stay ಮಾಡ್ಬೋದಾ? Promotion seniority is always subject to the result of the petition. Can I say if they have assumed charge saying that don't work?
Mayor, my lord,
Interim notice ಮಾಡಿ. Ineligibility may be there, but their promotion is granted subject to the result of the present petition. Correct?
they are not at all entitled for that.
ಅರೆ ಗೊತ್ತಾಗಿದೆಯಲ್ಲ ಪ್ರಮೋಷನ್ ಪ್ರಶಾಂತ್.
Because words.
We will fix a date, let them file their objections, we'll decide it. No question of staying promotions if they have already assumed charge.
No, Lordship. It is, my lord, the past notes after my lord filing of this petition.
Page.
No, kindly see notes. No, kindly see notes.
Page 5 that you ಹೇಳ್ತೀರಾ?
No, kindly see annexure N, Lordship, for a moment. Page number 1112, 112. It is already rejected. The promotion is already rejected. 112.
Come to page 8 of your memo, sir. You have filed some memo. The page 8 is bunny, 28/12/2024.
This is subsequently what has happened in Lordship. Kindly see 112, Lordship. Page number 112 of the writ petition. Lord, in this, after holding that, my Lord, the meeting resolution, my Lord, register has passed, my Lord, this endorsement has been given to the, my Lord, respondents month 4 to 7, stating that, my Lord, they are not entitled at all. And contrary to this, my Lord, again, my Lord, they hold one more meeting and, my Lord, given, my Lord, the
Sir, in writ petition 105854, the coordinate bench has held that they are entitled to promotion.
No.
Which is that order?
Petition number 1042112.
No, 105854.
That
which is pending.
That is pending for consideration. Wherein, Lord, this honorable court, Lord, subject to result of writ petition, Lord, it is adjusted.
Same one.
And Lord, now, final argument. Lord, one more thing, Lord. At least, my Lord,
Ramchandra Mali.
Lord, at least, my Lord, not to take, Lord, further any steps, Lordship. So
promotion ಆದ್ಮೇಲೆ further any step salary ಕೊಡಬಾರದು ಅಂತ ಹೇಳಕ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? Fix earlier date.
That
Lord will argue the matter.
That we will do. Yes. One HCGP, 2 I think Ramchandra Mali appears.
2 and 3.
2 and 3 Ramchandra Mali is directed to accept notice. 4 to 7 be served by way of hand summons. A promotion or any benefit granted to private respondents, i.e. respondents 4 to 7, shall remain subject to the result of the present petition. List the matter 4 weeks bit date code.
One date.
Our objections, if any, by the list on so and so.
Lord, it may be taken along with that matter, so that, Lord, in that case they have filed, Lord, the statement of objection.
A list on 5th February. Tag the petition along with 105854 of 2024. Objections, comma, if any, comma, by any, by then. Yes, next.
Please.
The heard the learned counsel K.L. Patil appearing for the petitioner. Learned counsel C. Jagadish is directed to accept notice for the respondent's petitioner to serve set of papers upon the aforesaid counsel. The issue in the list revolves around a caste certificate issued to the petitioner depicting him to be Sille Kyata. The caste certificate is said to have been issued by the Tahsildar after due verification, which comes to be doubted by the Civil Rights Enforcement Cell, and the result is the dismissal of the appeal filed by the petitioner against the cancellation of the caste certificate. The matter would require consideration. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing.
So, one pertaining to
Veer
Dasar and Channadasar, is the issue. The appellate authority has remanded the matter to the DCVC. That order is in question. Firstly, on 2 technical grounds and on the factual grounds also.
It was C. Jagdish, same order. Learned counsel, C. Jagdish. C. Jagdish is directed to accept notice for respondents 1 to 8.
9 is the person who filed the complaint.
Emergent notice to the 9th respondent. With on date code. List the matter on 5th February again in the fresh matters test. Till such time, the orders impugned shall remain state.
Okay. DCVC proceeding start madibittiದ್ದಾರೆ.
Yes. Next.
Lord, I am hearing for the I am seeking random. Lord, preparation of total is bank records have been forged and the daughter of the minister has been included in the workplace. I have produced the evidence to show that project has been committed.
Sir, Learned HCGP is directed to accept notice to the R2 and 3. So the second respondent. Go through the papers with regard to the allegations and make submissions. List on Monday 13th. I know that. It's list on 13th. I'm not saying anything. Yes.
Much of it.
Monday is next.
Please.
Petitioners are seeking also voting rights and just the election.
Yes, madam. Voting rights will grant. Separate ballot box, same order.
Yes, similar circumstances under court not granted the
Now, whatever division bench has said, we will do the same thing. Yes. Same order, sir.
interim order. Similar matter not interim order granted.
Good here. Is pending is
Yes, ma'am, pending.
Tag this petition along with 107-824 of 2024. The coordinate bench has granted an interim order which reads as follows in identical circumstances. The learned HCGP would place on record an order passed by the division bench. It is against this order, is it?
No, ma'am.
Ah, that's all right. So, by division bench, but it must. Learned HCGP accepts notice for
1 and 3.
1 and 1 emergent notice to the other respondents. Yes.
Voting rights and contesting.
ಇಲ್ಲಿ ಏನಿದೆ
Yes,
ಸೇಮ್ ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ
Yes, ಅದರಲ್ಲಿ ಇದೆ ಮೇಡಮ್ ಕಂಟೆಸ್ಟಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ ಏನಿದೆ ಅದು
Yes.
Yes.
I seek hand delivery.
But this is after the division bench.
After division bench, no, this order has been passed now.
This may be typographical mistake. Separate ballot box ಅಲ್ಲಿ ಹಾಕಿ ಹೇಳಿದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದರಲ್ಲಿ single.
Why you did not bring this to the notice of the court? 24/12/2024 order notice.
After that note, this order has been passed.
Huh?
After that note, the single bench.
This order was brought to the notice. Which order is passed? ಆಮೇಲೆ ಇದೇನೆ ಈಗ ಹೊಸಮನಿ ಸಾಹೇಬ್ ಆರ್ಡರ್ ಫಾಲೋ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. It runs counter to division bench then. Look into this, sir. Division bench order ನೋಡಿ. Really? Yes. Passed 3 days prior to that order.
Kindly pass on notes.
Pass on.
Please.
Contesting very difficult. Voting rights definitely I will also grant.
I will verify. Kindly pass.
Other separate ballot box, all that is there. See, declare the results. If there is any problem, then idana ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ. That is the general order that is passed.
Yes.
Yes, next.
Petition challenging appointment of respondent number 3 as managing director.
Correct. If somebody is, as he assumed charge?
No, he is trying to assume charge.
Trying to?
Please. He has informed that he will take suo motu charge from today.
Suo motu charge. Once extend ಮಾಡಿ ಮತ್ತೆ why all this again? Drama. Why this drama again?
Because they are not allowing to take charge. So now it is again changed.
1, 2, 3 ನೀವು 4 4 ನೀವೇ commissioner of Ken, all AGA for all the respondents. The impugned order shall remain stayed only if charge has not been assumed by the third respondent as on today. Yes, next. Earlier interim order, sorry.
Seeking for the permission to send the.
Correct. Justice Sanjay Gowda order like that. Same order.
Page number 91, 92.
No, page 86, 87.
86, 87, and
90?
91.
Same.
91, 92.
All these matters are pending.
Yes.
Bangalore, I have also passed some orders. Yes. Tag this petition along with page 91 or 86. ನಿಮಗೆ ಯಾವುದು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್ ಎರಡರಲ್ಲಿ both 20 and 21 ಅದ್ರಲ್ಲಿ ಏನು ಮಾಡಿದ್ದಾರೆ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ ಸೇಮ್ ಆರ್ಡರ್ ಅದ್ರಲ್ಲಿ ಏನು ಮಾಡಿದ್ದಾರೆ ನೋಟಿಸ್ ಇದೆ ಅದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಸೌರಭ್ ಅಮೆಂಡ್ಮೆಂಟ್ 21 ಬೇರೆ ಏನಾದ್ರು ಕೊಡಿ
Start from page number 103. Rules and regulations.
Entry motors are granted in this also.
Same. That is regarding solar vehicles.
103, 104, 105 tag same order. Next. What amendment?
I have sought for amendment because I need to challenge the election R3, that is the seniority list. I need a week's accommodation because I need to produce the certified copy of the letter.
Learned Counsel Saurabh Hegde seeks a week's time. List the matter.
We will not appeal for respondent number 2 to 5 years.
One ನಿಮಿಷ 1 minute. Social Welfare Department ನೀವು ಅಪೇರ್ ಆಗಲ್ವಾ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ
Central Relief Committee.
ಇಲ್ಲ ಮೇಡಮ್ R1
R1 ಇದೆ. R2 to R5 ಇದೆ.
Make one submission.
Central Relief Committee ಯಾರು who is
What happened is this petition was disposed earlier. Then I filed a review.
it was recalled.
Yes, it is recalled.
All
Kindly see the order. There they have appeared. Kindly.
They don't appear.
As per my instructions,
ಅಲ್ಲ if you serve on the appropriate authority it is good for you. First dismiss ಆಗಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿತ್ತಾ yes. Learned Counsel Saurabh Hegde seeks a week's time. List the matter after a week. Learned HCGP submits that the state does not represent respondents 2 to 5 and it would Nishrita Relief Center. Central Relief Committee ಯಾರಿಗೆ ಬರುತ್ತೆ ಅದು ಸೆಂಟ್ರಲ್ ಅಂತ ಇದ್ದ ತಕ್ಷಣ ಇಟ್ಸ್ ನಾಟ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಇಟ್ ವುಡ್ ಬಿ ಸಮಥಿಂಗ್ ಎಲ್ಸ್ ವೆರಿಫೈ ಮಾಡಿ ನೀವು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಷ್ಟು ವೆರಿಫೈ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ 27th all right yes
In the meantime, I will be sending the notice.
ಅಷ್ಟೇ
R5 to R6. I will send the notice also.
ನೀವು ಟೈಮ್ ಬೇಕಾ ನೋಟಿಸ್ ತಗೊಂತೀರಾ ವಾಟ್ ಡು ಯು ವಾಂಟ್ ಟೈಮ್
No, emergent notice to this 5 because
ಕೆಲಸ ಮಾಡಿ ಒನ್ ಸ್ಟೇಟ್ ಅಂತ ಮಾಡಿ ಮಿಕ್ಕಿದ ಎಲ್ಲರಿಗೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಆನ್ 27 ಎಸ್ ನೆಕ್ಸ್ಟ್
R7 has appeared already.
R7 is served.
So Chetan,
He appears, is it?
he appeared in the previous writ petition.
R6, yes.
R6.
Next. Now they have issued a notification in 1977 declaring this to be a slum.
After that,
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು? Why have you moved it now?
No, the reason is not, it's a short matter, my lord, we have filed a memo for disposal, and my lord, we are taking some prestative steps.
R2 to R5 ಇವ್ರು appear ಆಗಲ್ಲ.
R5 also, my lord,
You serve on any council who represents the slum board, slum clearance board. Now it is slum development board.
please, I serve on Raviraj party. CMC, my lord, is only a formal party. In 1997.
No, you serve on the board.
There is
Board is the contesting respondent.
contesting is 1, 2, 3 and 5.
Joint Council Raviraj Party is directed to accept notice for respondent 2, 3 and 5. 2, 3 and 5. One next date agidiyala. 2, 3 and 5. List the matter on 27th. ಇದು ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಈಗ ಟು 2020?
I have not moved.
Who has moved? Sale deed is cancelled.
Sale deed is cancelled, madam.
Stay ಇಲ್ವಾ?
Stay ಇದೆ, madam.
Yes. ನೀವು ಮೂವ್ ಮಾಡಿದ್ರಾ? Who is this man who is in charge? Madam, mouse ಅಲ್ಲಿ. Yes, miss. ಯಾರು? Who is that Ajay? Close ಮಾಡಿ. Serial number 24, is it? R1? You are 24.
Right.
Who is this man 24? Huh? 2 weeks to do the needful. Yes.
Entry borrow marriage. Entry borrow marriage.
ಇದೆ entry model. Idre extend. Yes. 25.
Put it address in like
2 weeks to do the needful. Yes. You are the husband. Huh?
yes.
Arrears ಎಷ್ಟಿದೆ?
Arrears at rate of 10 is direct. There is time. It is time.
All right. Let's see. Yes. In the event steps are not taken, the interim order would get vacated. Yes. Next. Name bitte. Recalling.
Recently we have filed a wakalat on 17/12/24.
No, recalling what?
So we need weeks of time to file
My order.
statement of
Allah.
opposition. This petition was filed in 2008.
Matter is of the year 2000 left with no other alternative dismissed for non-prosecution.
It was dismissed for non-prosecution in 21 now. I have applied for application. I have filed for condemnation of delay and as well as restoration.
1035 days delay. Just 3 years delay alone. Objections are put.
Weeks of time may be granted, my lordship. to file.
Lieutenant counsel appearing for the respondent seeks 2 weeks time to file statement of objections.
My lord,
15 years.
Advocate Rahman Shah's name may be deleted.
Whose name?
Advocate Rahman Shah.
Rahman Shah to be deleted.
Yeah, ma'am.
And whose name to be printed?
Sajid Budwala.
Counsel registered to delete the name of Ahmed Ali so and so and print the name of Sajid Kudwala and retain the name of Sajid Kudwala. Yes, next. Dispensation. Order sheet kodi madam. Order sheet need to ಮಾಡ್ತೀನಿ. Enter order ಇದೆಯಾ? ಇಲ್ಲ. Lieutenant counsel Vishwanath Hegde seeks 2 weeks time to file statement of objections. List of 2 weeks.
My letter, respond number 3.
For the third respondent. Vacating stay.
ಏ ನೀರ್ ಬರಾಕತ್ತೈತಿ ನೋಡು.
Lord Khan.
Sorry my lord, sorry my lord, sorry.
Yes. No, why? Vacating stay the man.
False certificate not
No, because his issue is not with regard to the certificate, with regard to the jurisdiction.
jurisdiction. Amendment to the
Huh?
provision.
Which provision?
Scheduled caste and scheduled tribe.
ಆಯ್ತು, ಏನ್ amendment?
4B, DC can decide it. That is the first, they earlier petition, they have contended that the deputy commissioner has authority to pass an order. This honorable court was dismissed petition on the ground that there is alternate remedy. Accordingly, approved the deputy commissioner. Deputy commissioner notes on 4B,
he passes an order.
Deputy Commissioner is not the one who is empowered to pass the order under 4B. Who is the authority to pass orders under 4B?
No, sir, 4B is the deputy commissioner. Person agreed by the Tahsildar, so and so, 30 days, so and so, the assistant commissioner for the revenue sub-division. Assistant commissioner of the revenue sub-division may, after giving authority, so and so.
Assistant Commissioner. Deputy Commissioner is not the authority under 4B. Now, the appeal is filed before the appropriate authority. Appellate authority is considered everything. He has jurisdiction. But the original authority is to be the Assistant Commissioner and not the Deputy Commissioner. And if the original authority had no jurisdiction, it cannot be cured by the appellate authority. Quorum non judice. As simple as that. Hello, Marana? Ashte. Time beka. ಓದ್ಕೊಂಬರಕ್ಕೆ
Some writ appeal is pending, what the council has said.
Which writ? Against what order?
Challenging the interim order.
Against what order?
Challenging the interim order.
You tag this also. Final order challenge ಮಾಡಬೇಡಿ ಜೊತೆ.
Now we told.
Shilvan sir, it is language is plain and simple. Under 4B, it is the Assistant Commissioner who is empowered to answer the challenge to the order of the Tahsildar. Here, the challenge is answered by the Deputy Commissioner. Admittedly, no jurisdiction. And it goes to the appellate authority. Appellate authority correct that will not cure the defect. Because the original authority is quorum non judice. That's all. What's your name?
Kavita S. Jala.
Yes, Shilvan sir. Liberty will be reserved. Liberty is always there. There is anything. A petitioner is before this court calling in question an order dated 24/3/2022 passed by the second respondent, appellate authority, rejecting the appeal filed by the petitioner against the order passed under section 4B of the Karnataka SC and ST and other backward classes within bracket Reservation of Appointments Act 1990, hereinafter not referred to as the Act for short. The issue revolves around a hurt so and so. The issue revolves around a narrow compass as to who is the authority to answer the challenge to the order of the Tahsildar. The petitioner is issued a caste certificate belonging to that depicting him to be belonging to Veer Kudi Vellam. This is when was it cancelled? Four B Assistant Commissioner ಮುಂದೆ ಹೋಗಿದ್ದಾರಲ್ಲ. Shilvan sir, 4/12/2021 is whose order?
21. Earlier was cancelled.
Well, at least tomorrow in the fresh matters list. The orders are ಬಂದಿದೆಯಲ್ಲ. At least tomorrow in the fresh matters list.
Yep.
Why deaf?
ನಾಳೆ ಗುಲ್ಬರ್ಗ matters. Yep.
ಏನು ಆಗೋಗಿದೆ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ಕಷ್ಟೇ. 20 ಅವರಿಲ್ವಾ? Yes, next.
Might play your lordship for the petition in this case.
66 days recalling the application.
Dismissed for non-compliance of office objection, your lordship.
Okay. Order on IA. For the reasons, the petition, the coordinate bench of this court on 30th August 2024 rejects the petition for its non-prosecution on the score of non-compliance with the office objections. The petitioner has thus preferred an application seeking recalling of the said order. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the order stands recalled. The petition is restored to file. 2 weeks' time is finally granted to comply with the office objections. Next.
Much obliged.
here for direction.
What happened is the arrears may not survive now. Main matter will have to be.
Main matter also won't survive?
There's a main matter is of the but the relief that we are seeking is against the respondent number 1 and respondent number 4, which is the railways. The fulcrum, my lord, of the matter is this: whether workers, Safai Karmacharis, who have served for between 4 years to 20 years, can just be discarded by the railways under the guise that there is a tender that has been given. That is the question, my lord, for this honorable court. An order was passed.
What's your right?
My lord, there are judgments of the honorable court, division bench of our own high court, which has said that even insofar as contractual workers are concerned.
No, is it replaced by another set of?
Yes, replaced by
then
another set. They cannot be replaced. That is the argument.
Kyara Singh, sir. Yes.
From Kyara Singh onwards, my lord, Dhiru Nayak, Preeti Bandige, after that Manish Gupta of the Honorable Supreme Court.
No, if you are the contesting respondent.
For the contract.
Contract. One contract by another contract. Permanent employment madangidre court will not interfere.
I participated in.
Railways has to answer.
And the same contractor, my lord. Facts are this. This contractor, my lord, was the preceding contractor as well. These were the union raised the dispute that there is non-payment of minimum wages, so on and so forth. During the pendency of those proceedings, this contractor is reappointed as the contractor. And under the guise of this reappointment, all these workers who are before the labor commissioner saying that we have not been paid minimum wages, they have all thrown to the streets. We come before this honorable court on 21/4/2023. This honorable court granted interim order as well.
You are continuing now.
Yes, illa, they don't comply with that. They don't comply with that. They challenge it in writ appeal. There is no stay that is granted.
Writ appeal is pending.
Writ appeal is pending, but writ appeal, the order that was passed on the last occasion was a request to this honorable court to dispose the matter, the main matter.
Where is that order? Put it.
So they have moved under the Industrial Disputes Act also, they have moved.
They forget it, they will withdraw everything.
Matter is now and proceedings have commenced. That's a separate matter. Railways, my lord.
That is with regard to their claims of non-payment of salary and other things.
And railways.
Now, if one set of contract employees are to be replaced by another set, that is clearly impermissible. Even Uma Devi recognizes that.
I have, my lord, participated in the tender and have been successful. So, my lord, there is no condition prescribed, my lord, in the tender that these workers have to be compulsorily taken on board.
No, that's not that cannot be the condition of tender also.
Yes, so now I am working with about 50 workers. And that much is enough for my purpose. This is for the purpose of maintenance of Hubli railway station.
Oh, true.
Now they are about 92. Some of them, my lord, are already working for me. Now I cannot take all 92. There is no work. And if I have to take 92, my lord, the railways have to reimburse.
Who appears to the railways?
Mr. Kharvi, my lord, Venkatesh Kharvi. And the railways have repeatedly taken a stand, even before the conciliation authority, that these workers should be taken back. And they take the stand over there that the respondent number 7 is the person, is the entity that is refusing to take them back. They undertake that we will persuade them. The Safai Karamchari Commission, my lord, was.
Harsh Desai, sir. The very induction of you in a new tender to replace the earlier contract employees itself is illegal. That can't be done.
Yes, sir, but now.
When was this? 1 year ago?
23, my lord.
For how many years tender is?
Now, my lord, tender is over, my lord.
Over.
So, they took Matra. For transitional purpose, my lord, for 31st of January, it is extended. Please, my lord. So,
we will decide the issue then.
That issue can be decided, my lord.
Henceforth, let this problem not get cropped up.
Please. But 31st, it will not be beneficial either to.
No, I will only hold that one set, it's settled principle, sir. One set by another set of contract employees cannot be done.
For the next.
Next set, union aitala.
See, they are saying that their contract is over. They will leave with their set of workers.
These workers have been there for the last
No,
20 years.
we'll direct the railways to follow the law, that's all.
Please, that can be done, but my only concern
ನಿಮಗೇನು ತೊಂದರೆ ಆಗಲ್ಲ. 31st January is only 3 weeks away. We'll post it on 20th.
20th.
List on 20th. Even if I am holding it to be illegal, this you will not get affected by it.
Because my lord, there is also another aspect. This is the same tender, the same contractor who existed before. He has been convicted by the court for violations of.
That's a different cause of action.
The reason I'm bringing this to my lord's attention, the railways, my lord, they pass a circular saying that any contractor who does not comply with the labor laws should not be entertained. Now, despite knowing all that, my lord, they grant him the tender and he throws all these workers out. So that's an aspect.
Well, say on 20th we'll close it. Right, the 21st. Okay. List on 21st.
In the same, at the same stage, please, my lord.
Same stage, yes. List on 21st. No, it's not, momentum has not gathered, so don't worry. Yes.
Allah, but I'm well aware, my lord.
We're still on the second. We're still on the second day. Yes.
My lord, I'm sorry, my lord. Can it be on 22nd, my lord?
Harsh Desai, sir. Agboda. 22nd. Yes.
So many times we have taken models.
ಏನು IA1
Production of documents, certain documents not produced.
ಅದರ ಮೇಲೆ ಏನು ಬೇಕು? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ, subject to result of the writ petition.
ಆಗಿದೆಯಲ್ಲ ಅದು. All applications to be heard along with the main matter. They list the matter on 21st. Yes. To make clear, no further adjournment would be granted in the matter. Yes, next. First time ಬರ್ತಾ ಇರೋದಾ?
It's coming for the first time. Before your lordship.
Yes.
Your lordship, there is a syndicate resolution, your lordship, they have already.
Mandamus to implement syndicate resolution. What's it?
Only difficulty is not
Then why did you resolve if you have difficulty?
not previously before the petitioners were before the Supreme Court by the HSJ, Lord.
Page
61. Order is passed, Lord. University is in appeal, Lord, before the division bench. Lord, only difficulty is the Lord, decision was taken to withdraw, Lord, the pay scale that was granted at the time of their appointment, which was, Lord, wrongly granted. Revised pay scale 2006. Lord, this recruitment was initiated in 2007-8. Appointments were, Lord, issued in 2012. By granting, Lord, revised pay scale, though, Lord, they were assessed against pre-revised, Lord, qualifications and pre-revised, Lord, pay scales were notified. Against that, Lord, they had approached the Supreme Court. The writ petition was allowed. Now that is, Lord, pending before the Lord, division bench. Lord, promotion again, Lord, if the writ appeal ultimately arrest otherwise.
What is the date of the syndicate resolution?
2022.
Right after the filing of the writ appeal.
No, your lordship. Writ appeal was filed subsequently.
Subsequent.
This was the first result. The syndicate resolved this resolution, your lordship.
No.
After we filed this mandamus, your lordship, since the representation.
Writ appeal ಹಾಕಿರೋದು ಆಮೇಲೆ.
Yes, your lord. Writ appeal they filed
Only
after a year, your
Lord,
lordship.
with a view to see that multiplicity of, Lord, litigations is avoided. In the writ appeal, Lord, they made a submission that they would not precipitate in the.
No, your lordship. This was not.
Precipitate this.
There is, Lord, different.
In the writ appeal, before the division bench, have they undertaken that they would not precipitate this?
There
There was no undertaking as such.
is submission.
ಯಾವತ್ತಿದೆ writ appeal?
There is
ಈ week ನಲ್ಲಿ ತಗೊಂಡು, Lord, we shall get the orders. Otherwise, Lord, it could be disposed of, Lord.
The learned counsel Ramchandra Male, representing the respondent, submits that against the order on which the learned counsel for the petitioner places reliance upon, the university has preferred an appeal, and the appeal is likely to get listed in the week or the next week, in the subject week or the next week. In that light, list this matter on 20th. In the event there is no order before by the division bench, the matter would be considered on its merit and disposed.
22nd.
22nd. Yes.
Much.
Next. Direction. Direction.
week time, objections are ready.
Learned AGA 6, a week's time to file statement of objections. List the matter on 20th. Objections, if any, by then. Next.
Temporary employee has been dismissed from service without conducting an inquiry. Dismissal is stigmatic. The charge against the petitioner was that she expressed her intention to contest in the assembly election. That was the charge. That was denied. Now, annexed D, my lords, is the tuned order.
Fresh matter, either.
Fresh matter. In fact, my lord, the honorable court was about to render interim order at that stage because the matter is covered. My lord said,
Yes, it is covered.
the government said they will file objections. They filed detailed objections, but no.
Yeah, you are out of service or in
I'm
service?
out of service.
Then no, by way of interim order, we can't do it. Yes. You have filed?
Objections.
List the matter on 16 in preliminary hearing. Yes, next. Week's time. Direct counsel 6, a week's time to do the needful. List a week's time is granted to do the needful. Next. Early hearing.
Objection.
What is early hearing?
I have filed that.
Why?
Because my selection has been cancelled by the honorable district court. Only on the basis that I have not completed schooling in my regular course. My lords, the district court, honorable district court, that is the respondent number 3, has cancelled my selection. Only on the basis that I am not a I have not taken regular schooling, and I have completed my SSLC as out of school student. Only on that basis, my lord.
Objection, Saki.
Objection, sir.
Learned counsel Jagdish Patil 6, 2 weeks time to file statement of objections. 21st in preliminary hearing. Objections, if any, by them.
If the lordship permit, the only contention, my contention is that annexure E, that is the selection which was cancelled by the respondent number 3. It may be caused and direction may be given to.
Or objection, Saki. Let him file his objection.
21st, before
Yes.
that, you'll get this.
21st, yes, yes.
Please, sir.
Recalling the order, dismissing non-prosecution. The coordinate bench of this court, in terms of its order dated 21st November 2024, terminates the subject petition on the score that there was no representation for the petitioner both in the forenoon and in the afternoon. An application is preferred seeking recall of the order for the reasons indicated in the affidavit accompanying the application, and being satisfied with the same, the order stands recalled. The petition is restored to file. Yes. Disposal of WP. Yes, sir.
The very order on what he is relying, your lordship, I have challenged in the writ petition 106726. Is the order of compulsory retirement made by the management.
Now you are the employee.
I'm the retired teacher.
Compulsory retirement yake?
Your lordship.
In the year 2015, there is some allegation he has failed to complete the syllabus for the year 2014 and 15. The management contended they have conducted inquiry and.
You are ready?
Please, sir.
Tomorrow in preliminary hearing.
Please.
Yes.
But I will take this notice in this point number 5 in the connected. I am the contesting party connected.
ಯಾವುದು 106 ಅಲ್ಲ ಬೇರೆಯವರು ಸರ್ವ್ ಆಗದ್ ಬೇಡವಾ
ಅಲ್ಲ ಬೇರೆ ಇಲ್ಲ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಇದೆ
learned HCGP is directed to accept notice for respondent 1 to 4.
Please, I am taking.
Counsel MS Harvey accepts notice for respondent 5.
6 may be dispensed.
Both the counsel for the petition and respondent submits that no relief is sought by 6th respondent. Therefore, notice is not issued to the 6th respondent. Please tomorrow. In preliminary hearing. Ashtedri will dispose it. Yes.
some urgency in this matter, my lord.
What urgency, sir?
My lord, the petitioners, my lord, were relieved from service. Totally 37 workers were relieved from service.
Already relieved?
They were relieved from service, my lord. 21 of them, my lord, had approached this honorable court. This honorable court, my lord, allowed their petition. And, my lord, there is an order passed for reconsidering their case, my lord. And the balance, my lord, 14 persons have filed this petition. Same order.
Can't pick and choose like that. Court bandila anta, you can deny them relief. No. The petitioners are before this court seeking the following prayer. The petitioners who are, the petitioners who are 14 in number are the ones who appear to have been left out or who did not knock at the doors of this court, while the cases of others were considered by a coordinate bench of this court in page 55. The learned counsel for the petitioner submits that the petitioners in the subject petition are similarly placed like that of those petitioners which formed the consideration of their cases at the hands of the coordinate bench noted supra. The coordinate bench has held as follows. Come to quote from para 10 till the end. In the light of the petitioners being similarly placed, they are entitled to similarly placed. Relief to them cannot be denied on the score that they did not knock at the doors of this court. Therefore, the petitioners become entitled to the same relief if they are similarly placed. The petition is thus allowed on the same terms of what the coordinate bench has directed in the aforesaid petition. Ordered accordingly. Next. Vacating interim order. Okay.
File with 40 and 41 will not go to the same issue. Suspension order will not be filed in serial number 40.
90 days.
Security guard.
90 days.
What?
40, 90 days adre? Ajay Kumar
no
Chaudhary. Ajay Kumar Chaudhary.
No apprehension. No apprehension is.
A security guard, my lord, is sleeping on duty.
Sleeping on duty?
And this is not a solitary instance.
The reason was, my lord, assigned by the vigilance officer after holding the inquiry. He was continuously on double duty for almost 1 month. He applied for leave because he was unwell. Leave was rejected. He was asked to perform the duty. He was, my lord, taking medicine. That was reported by the vigilance officer to the. This report I will place it before the court, my lord. I got it.
You can't harass an employee like this. He will obviously sleep.
As far as my lord says.
No, the vigilance officer himself writes, my lord, a report that he, in fact, applied for a leave. He was unwell. And there are, out of 6 sanctioned posts, there are only 3 persons working, and they are stressed. Therefore, he also recommends for sanction of more, my lord, constables.
That my lord, I have
report there.
Report, my lord, I will place it and got it, my lord, subsequently by applying.
Our report.
I'll ascertain that.
Yes. List on 16th in the fresh matters list. We'll dispose it on that. Ide adre kashta.
I will verify.
You can't overburden someone and ask him not to sleep also. Yes.
Serial number 41, my lord. 41, my lord. Suspension order has been, my lord.
41 is the same alla.
No, it's not.
Maybe agreed. 41 nimdane.
This is fully covered by this honorable court judgment.
41 yen. What is challenge?
Suspension order has been challenged by the, my lord, the petitioner hearing. My lord, the petitioner is a conductor. He has not issued 4 tickets to the, my lord, passengers. That's why, my lord, inquiry has been.
Inquiry is on. I am facing inquiry.
Yesterday's matter.
They have implemented.
Yesterday's matter.
No,
my lord.
That's not a.
None order ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
You are there are 5, my lord.
ಇದು notice ಕೊಟ್ಟಿಲ್ಲ ಅಂತ stay ಮಾಡಿದ್ರು suspension. I have dismissed all those petitions on the ground that notice need not be issued. Prior to the
My
2021.
Lord, articles of challenge has been issued. Thereafter, my Lord, suspension order has been challenged, order has been passed by the, my Lord, any KRTC. That order has been challenged before this honorable court, and my Lord obtained the stay.
Yes, sir.
My Lord, now, my Lord, the enquiry is stopped due to stay passed by this honorable court.
Enquiry is stopped, Modulus. Enquiry is on. I have been issued with a notice. I am participating in the inquiry as a particular
Suspension stay.
suspension, my Lord.
Charge sheet issue ಮಾಡಿದ್ಮೇಲೆ suspend ಮಾಡಿ ಏನ್ ಮಾಡ್ತೀರಾ?
ಒಂದೇ ದಿವಸ ಮಾಡ್ತಾರೆ ಅವರು. ಒಂದೇ at a time suspension, at a time same order.
Suspension, there is some purpose. ಸುಮ್ಮನೆ not for your satisfaction you suspend someone. You would not tamper with the records. ಅಲ್ಲೇ ಅದೇ ಇದರಲ್ಲಿ ಇದ್ರೆ ನೀವು ಸಸ್ಪೆನ್ಷನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಒಂದೇ ದಿನ ಆದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಕಮೆಂಟ್ಸ್ ಆದ್ಮೇಲೆ ಟ್ಯಾಂಪರಿಂಗ್ ಏನು?
My Lord, enquiry officer also appointed.
Correct, sir. What is the use of suspension? Or you give him to some other post?
My Lord, already, my Lord,
It's a loss to your corporation.
Interim order, my Lord, already complied by the, my Lord, honorable.
Already continue ಮಾಡಿದಿರಲ್ವಾ? ಮಾಡಿ. The learned counsel for the petitioner submits that the counsel for the respondent corporation submits what is challenged in the case at hand is an order of suspension, and there is no ground that is projected to challenge the order of suspension. The learned counsel for the petitioner submits that the petitioner is suspended and the charge sheet is issued on the same day. The purpose for which the suspension should be passed is completely violated in the case at hand. The matter would require consideration. There is already an interim order granted at the hands of this court. It is made clear that the order of suspension is stayed and not the inquiry against the petitioner. Yes. List the matter after 2 weeks on 2-3 weeks. Next.
I find this high for impleading.
ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ತಾರೆ?
Please, madam.
Whom do you want to implead?
Petitioner, madam.
ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು ಸರ್?
Principal Secretary, Medical Education, madam.
Government.
Yes, madam.
For the reasons indicated in the affidavit accompanying the application, IA1 and being satisfied with the same, IA1 of 2024 is allowed. The Principal Secretary, Department of?
Please, ma'am.
Which department?
Medical Education, madam.
Medical Education Principal Secretary,
yes, ma'am.
The Principal Secretary Medical Education is who is sought to be impleaded is permitted to be impleaded as a party respondent. Respondent number 5. Is directed to accept notice for the respondent number 5 petitioner to serve set of papers upon the aforesaid council and amend the cost rate. Yes. Unmute ಮಾಡಿ. Yes, sir. IA for dispensation. Order on IA. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, IA 1 of 2024 is allowed. The production of certified copy is dispensed with for a period of 8 weeks. Yes. 8 weeks. List the matter day after tomorrow in the fresh matters. Next. 9th. Same order. Day after tomorrow, fresh matters. Yes, next. Adu, urgency idea?
I'm filing memo for withdrawal.
Good. Thank you. Yes, good. Counsel for the petitioner files a memo seeking to withdraw the petition in the light of the memo, so filed petition disposed as withdrawn. Next.
Lord, next week. Next week.
Next week?
Yes.
Why, sir?
I'm including the application. 129 members in including
Current
application.
counsel for the petitioner seeks a week's time. List the matter on 21st. Next.
The appointment of the petitioner, my lord, in 2010, my lord, new college, my lord, graded institution, has been admitted, my lord, to salary granting aid, my lord, by the Annexure C order at page number 25 in the year 2017. That has not been, my lord, implemented, and the salary, my lord, has not been disbursed, my lord, by the government. When, my lord, the request was submitted to the government, my lord, issues a endorsement at Annexure G, page number, my lord, 45. Stating that there is a suit, a civil suit pending, my lord, between the my lord, members of the management, and there is no full workload, my lord, to the Kannada lecturers course.
Depute Madilvan in the ಬೇರೆ ಕಡೆಗೆ.
My lord, he was deputed. There are orders at Annexure D series, my lord, in the government, my lord, colleges.
Now where are you working?
Now, my lord, in the fifth respondent. Now they come up with a, my lord, contention that the government has my lord, banned deputation of private aided institution employees to the government colleges. But again, my lord, in 2024, after that, these, my lord, the excess, my lord, employees are being deputed in other aided colleges.
Yes, madam. When do you pay his salary? It's all right. When do you pay his salary? You are making him work without payment of salary?
Your Worship, there was a dispute between management.
You may have any dispute. You can't make someone work without payment of salary, madam.
Any information regarding the petitioner to the.
ಈಗ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆಯಾ ಎಲ್ಲ? ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀರಾ? The learned HCGP to secure instructions as to when the salary of the petitioner which has been left unpaid for how many years?
2017.
For close to 8 years now, despite the fact that he was deputed to teach in an institution which had adequate workload in terms of the extant guidelines prevailing then, to be complied with. Yes, when do you comply with it? List on 20th in the fresh matters list. It is made clear that if no decision is taken by the state to disperse salary of a teacher who has worked throughout these years, the matter would be viewed seriously. 20th. Okay. Salary ನಿಮ್ಮ officer ಅದಲ್ಲ madam, teacher. If your officer who has dodged him is taken away of salary for 3 months, ಗೊತ್ತಾಗುತ್ತೆ. Yes. 21st, all right.
Grace.
For the response 2 to 4 minutes. For my statement of objections, rejoinder has been filed. I seek for a week's time accommodation.
Pleadings are complete? ಏನ್ tender?
15th or 16th, we can post on 15th or 16th. I have filed my statement of objections. The petitioner has filed rejoinder for 16th.
List on 16th in the same stage. Yes.
Case contact?
No, matter is around with the Telegraph Act, my lord.
Yes.
This has already passed order for compensation as well as laying out.
Section
He has
10.
encashed 16.
10
10 ಆಗಿದೆ. 16 ಅಲ್ಲಿ district court ಮುಂದೆ reference ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ.
ಅಲ್ಲಿ announcement ಇಲ್ಲಿ ಕೇಳಕ್ಕಾಗಲ್ಲ. ಕೊಡಿ. The petitioner is before this court seeking the following prayer. Land is acquired, is it?
Laying of the line
for the purpose of laying of the electricity cable, the KPTCL appears to have utilized the land of the petitioner by granting compensation. The petitioner is before this court calling in question the order of the Deputy Commissioner passed under Section 10 of the Telegraph Act, where compensation is determined after hearing the parties. Against the said order, the subject petition would not be entertainable in the light of the remedy under Section 16 of the Act to approach the district court, the identical issue is answered by coordinate bench in so and so, where the coordinate bench has held as follows. In that light, the petitioner is reserved liberty to knock at the doors of the appropriate fora, ordered accordingly. This petition is disposed. Petition is disposed, reserving liberty to knock at the doors of the appropriate fora. Next. That admission covered up. What's the offense?
The complaint is about essential commodities.
Section 10 not complied.
Section 19 of the.
Which judgment is that? Covered up. Counsel for the petitioner submits that the issue is covered by an order passed by this court in so and so criminal petition. Yes. List on 16th in the fresh matter. 16th fresh matters list. Yes. Justice. That we will do, sir. Yes. Registry to delete the name of SS Edrami and print the name of yes, so and so. Where is scale Patil, sir? 2012, sir.
Please, because the departmental inquiry, he admitted the charges. Upon his admission only the order was passed.
Where is the admission?
The page may not show. Page number may not 20. The order of the page number 20 below the third paragraph. The PA Pronik has submitted his reply to such charges sheet while his letter dated 2007, wherein he accepted all the charges leveled against him, however, adduced certain reasons for committing the said misconduct. And as a submission,
reduction to basic pen. What is the penalty?
Reduction of the basic pay scale. So, by show cause notice, we have proposed to reduce his pay scale from 22,280 to 13,820. And upon his request, we reduced it to 22,000 to 17,000.
It's all right, but where is scale Patil, sir?
I will inform them.
Password.
Please, I will inform them.
We'll close it. Yes.
We need to thank occupation of land as unauthorized cultivators. We made an application for regularization. Inquiry was pending.
64 inquiry ಮಾಡಿದ್ರ
ಆಮೇಲೆ 65A note ಮಾಡಿ forest officer passed an order taking possession of the property.
Yes, comment.
But according to us, it is not a forest land because
that's a matter of evidence.
Yes. Along with some of the statement of objection, everything will be represented for moment page 9 of
the objections.
Objection.
That's all the ground?
Our contention is, it was not a forest land, it was a government wasteland, Sada land. We were in cultivation. Our applications were pending for consideration.
Where is your application?
No, the next D series. And there is a spot inspection, annexure E series.
What is the opinion in the spot inspection?
Kindly I request page
spot inspection, it is said that it is not a forest land.
So this in spot Panchanama, they stated that they are in cultivation of the land for more than 33 years.
That does not take away the right of the forest department.
For that reason, for the first note, I request note page number annexure E, typed copy at page number 52. Next page, ಅತಿಕ್ರಮಣ ಕುರಿತು ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ಪೇಜ್ ನಂಬರ್ 53. ಅರ್ಜಿದಾರ ಹಿರಿಯರ ಕಾಲದಿಂದ ಕಳೆದ 30 ವರ್ಷಗಳಿಂದ ಸದರಿ ಜಮೀನು ಪೈಕಿ 1 ಎಕರೆ 33 ಗುಂಟೆ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದು ಅರ್ಜಿದಾರರಿಗೆ ತಿಳುವಳಿಕೆ ಬಂದಾಗಿಂದ ಸದರಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಾರೆ ಅಂತ ಅರ್ಜಿದಾರರಿಗೆ
ಅಡ್ಡಿ ಇಲ್ಲವೆಂದು. ಎಸ್,
my submission is, unless these proceedings are the notification shows that right to this land was declared as a forest land.
Where is the declaration?
No, But I have produced the government gazette of 1927.
Page.
No, page 9 of the statement of objection. Loan portion. Village,
Annexure R1. 18 January 1927.
27. Page 9 ದಲ್ಲಿ inspect of the survey number, whole survey number 26, even acre 35 meters. Melgade, page 9. Village.
ಯಾವ ವಿಲೇಜ್ ಇದು? ಮಾಂಜರ್ ಪೈ ಅದಾ? What proceeding have you initiated then?
Then this order is passed,
That is 1927. After that,
in 2010, you know, the first time order is passed. Order.
stay there again.
Stay.
Yes, sir.
First time was admitted land is the forest land.
After 90 years, you have passed this order.
But not that.
Oh, once a forest land, yes, that is there. Judgments are there. They can claim at any time.
Record of rights for the year around NDC, actually A. It is for the year 1931-32.
ಅದರಲ್ಲಿ ಏನು ತೋರಿಸಿದೆ?
ಅದರಲ್ಲಿ ಸರ್ಕಾರಿ ಪಡ ಅಂತ ಫಾರೆಸ್ಟ್ ಅಂತ ತೋರಿಸಲ್ಲ.
What's the difference? What's the difference?
One mutation entry is there, which indicates the owner did not pay the revenue, so it is confiscated to the government.
That is in 1933.
Yes.
But what happened to the application for regularization of unauthorized occupation? ಏನು ಮಾಡಿದ್ರಿ ಅದು?
This order is passed on Annexure.
No, yes. Dinesh Kulkarni took me to this page 53. ಅತಿಕ್ರಮಣ ಕುರಿತು ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ.
That are not concluded.
1 acre 33 guntas can be granted is what is, can be regularized is what is said. No, this is 21/3/2006. This is a subsequent thing. For 4 years, what has happened? Nothing.
I have to get the instruction on that.
You seek instructions. What has become of this? Otherwise, we will dispose it what was regarding what's to be done. List the matter on 16th in the fresh matters list. Mail bandre mugisidಬಹುದು. Yes.
Can be passed out.
Yes. Yes, Gurudev. What is under challenge?
The order, my lords, wherein the recovery proceedings, my lords, and has been initiated against the petitioner.
Departmental inquiry.
Departmental inquiry. He was, my lords, working. He was deputed, my lords, to the Karnataka Urban Water Supply and Drainage Board. He was early, my lords, an employee of Dharwad Corporation.
Mike on agilva. All right. Yes.
He was appointed. He was deputed, my lords, to the Karnataka Urban Water Supply and Drainage Board. There, my lords, he committed some default and misappropriation, and therefore, my lords, he was my lords, sent back to corporation, and they have, my lords, issued a mandate, my lords, for initiating the recovery proceedings to a sum of rupees 5,17,000. That is under challenge.
Inquiry madadra.
Inquiry is not. Notice has been issued, my lords, and the amount has been, the Karnataka Urban Water Supply and Drainage Board has to,
no, whatever, if you have recovered some amount,
yes,
or passed an order of recovery, there should have been an inquiry.
Annexure B, Annexure A is the included order.
Annexure?
Annexure A. Order is passed, but no inquiry is conducted.
Yes, you be ready. Tomorrow in the fresh matters list. Tomorrow fresh matters list. ಎಲ್ಲ ಹಳೇದು next part. Next.
On 31/7, there was an order by this court, wherein
31/7.
31/7/2022.
Madam, order sheet 31/7 are not available.
This is
yes. Anganwadi.
Correspond number 4.
Hello. Notification was only for widows?
Priority should be given to the widow. That's one of the petitioners is not widow. That's what the court wanted to know. Out of 3 petitioners, second petitioner is a widow. To that effect, Annex D is placed before the court.
So 1 and 3 have no ground at all. ಈಗ ಎಷ್ಟು ಪೋಸ್ಟ್ ಇದೆ? ಒಂದೇ ಪೋಸ್ಟ್. ಯಾವಾಗಿಂದ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? 2013. Is admittedly a widow. You are better qualified?
No, both qualification is basically self.
Yes.
Petition number 2 is only past 9th month. The respond number 4 past SSLC. As per Annex C1, 9th past.
You are better qualified.
Yes.
Qualification is only 7th. Requisite qualification.
Requisite qualification is
10th. Anything else? Close Marna? No ground. Yes. The petitioners are before this court calling in question an order dated 2/1/2013 by which the 4th respondent is appointed as Anganwadi worker at Basarkod village. First synopsis 1/8/2012. So and so. The petitioners heard so and so. The 3rd respondent, the Child Development and Project Officer of the Department of Women and Child Welfare, issues a notification calling for applications from eligible candidates for selection to the post of Anganwadi worker to the Anganwadi centers of Basarkod village, so and so. The 4th respondent comes to be selected and appointed as Anganwadi Karyakarte in the year 2013. The learned counsel appearing for the respondent state would submit that preference was given to the widows while granting appointment, while considering the cases of the applicants for the post of Anganwadi worker. This court, on the said submission, on 31/7/2024 had passed the following order. The court directed the petitioner to ascertain as to who were the widows in the amongst the petitioners to become eligible even for consideration of their cases at this juncture. The learned counsel for the petitioner submits that the petitioners 1 and 3 are not widows, and their preference could not have been granted. And in so far as the second petitioner is concerned, she is a widow and can be considered. The learned counsel appearing for the 4th respondent submits that the basic qualification for consideration of the cases for Anganwadi worker is a pass in SSLC. The second petitioner has only passed 9th standard is an admitted fact, while the 4th respondent, the appointee, has completed SSLC. Though both are widows, the qualification is fulfilled only by the 4th respondent in terms of the notification. The second petitioner, who does not fulfill the qualification of pass in SSLC, cannot be seen to contend that the 4th respondent's appointment is contrary to law. Therefore, at this juncture, after the appointment of the 4th respondent 11 years ago, this court would not now put the clock back and consider the cases of these petitioners who admittedly are not eligible to be appointed in terms of the notification. Petition lacking in merit stands rejected. Next. Delete ಮಾಡ್ಬೇಕಾ? ನಿಮ್ಮ ಹೆಸರು ಆಯ್ತು. Register to delete the name of J.M. Gangadhar. Next.
For the petitioner,
the
the petitioner institution, my lord, had submitted a proposal seeking to include under the salary grant, my lord. While considering the inclusion under salary grant in terms of 99 rules, my lord, only 7+1 have been included, and the additional posts, additional classes that were approved by the competent authority, my lord, have not been included on the ground that the order has been withdrawn. Lordship may kindly see the objection raised is that the joint director had not approved the additional classes, commencement of the additional classes. But my lord, as per the memo which I have produced along with the document, it shows that the deputy director who is competent to, my lord, approve the additional classes. And he has approved, my lord, on 28/2/2006 as well as on, my lord. But the first document is 28/2/2006, my lord, by which, my lord, the deputy director has approved one additional class for the A standard for 2006 and 7.
The learned counsel Vijay Kumar, representing the petitioner, seeks to place on record certain documents which, according to him, would run counter to the reason rendered for not accepting the cases of these petitioners to come within the ambit of grant at the hands of the state. List the matter on 21st in the fresh matters list. Instruction not by then. Next. Departmental inquiry.
Does not survive for consideration.
Why?
Because then this matter was referred to Lokayukta. Lokayukta has conducted the inquiry.
So
whatever the departmental inquiry conducted is challenging the inquiry.
So why do you say it does not survive for consideration?
Since one of the matter referred to Lokayukta and Lokayukta.
You have inquiry challenge matter.
The inquiry challenge the inquiry that was in the departmental inquiry. They have challenged before the authority as the next year.
Let him come then. List tomorrow in the fresh matters list.
But the petitioner had fulfilled all the conditions prescribed under Uma Devi's judgment, my lord, for the post of second division assistant. Now, my lord, the first respondent has directed the management to fill up the post through notification. That was under challenge, and the proceedings were stayed.
10 ವರ್ಷದಿಂದ stay ಇದೆಯಾ?
Yes, my lord, the proceedings have been they have not taken up further processing of the issue of.
You had already completed 10 years?
Yes, my lord. As on the day when the notification was issued, my lord.
That's all.
Lord, the notification was issued, my lord, on 8/2/2013.
Yes.
And 1/4/2003, my lord, he was appointed.
Now, after the interim order, another 10, 11 years.
Please, madam.
So it's 23 years, 20 years, 21.
Petitioner was overaged at the time of appointment. He was overaged by 1 month.
1 month? 1 month?
Please.
All right.
And his appointment was not in proper. And the institute has not taken any permission from the government while appointing the petitioner. Simply completion of the petitioner in service of 10 years does not provide any.
I the service of 10 years then. Now by interim order another 11 years. 21 ವರ್ಷ ಆದ್ಮೇಲೆ where did you send him?
But initial appointment is not.
It's all right, but where did you send him after 21 years?
Not against the sanction post fellowship. He was overaged at the time of the appointment.
Yes, Vijay Kumar sir.
My lord, I was not overaged, my lord. I belong to scheduled caste, my lord, and by virtue of the relaxation, I am entitled to.
Where do you demonstrate that you are an SC?
My lord, page 2, my lord, that he belongs to scheduled caste.
These are government, sir.
But that contention was not raised, my lord. They have not filed any reply.
Objections hakilva? Hakidara.
On 1/4/2014.
Lord, I have stated at para 6, my lord.
Para 6 ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
Lord, he submitted representation to the respondent requesting to consider his claim for regularization. Lord, apprehending that he would be overaged by 1 month. He sought for regularization of his services.
That is in 2013.
Yes, Manu.
Yes. He was not overaged at the time of appointment. At the time he sought regularization. 1 month al overage ಆಗ್ಬಿಡ್ತೀನಿ if you don't regularize ಅಂತ ಹೇಳಿರೋದು. Then how did you say that he was overaged at the time of appointment? Huh?
The court did not select the petitioner on account of his being overage by 1 month on the last day fixed for submission of the application.
What application? Yes, Vijay Kumar sir.
Please. As in the date of application, appointment, my lord, he was not overaged, my lord.
No. How were you appointed?
By the respondent management, my lord.
Why do they refer to the backlog rules?
No, that is because it is against a backlog vacancy, my lord. He was seeking regularization.
What was your age at the time of appointment? Was it beyond 29? Of course,
Lord, I need to verify that, my lord.
List on 21st in the fresh matters list. Yes. ಅದು ವೆರಿಫೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
Please.
Next. Yes.
Appointment of Angarwadi teacher on the ground that respond number 6 is not belongs to local area.
Belongs to?
The local area.
Local. Who appears for R6?
R6 units, the advocate appeared for R6 is no more.
Notice ಹೋಗ್ಬೇಕು ಮತ್ತೆ 10 ವರ್ಷದಿಂದ ಹಂಗೆ ಇದೆಯಾ? Why it does not survive?
Again, I'm called further instructions.
ನಿಮಗೆ ಬೇರೆ ಕಡೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಸಿಕ್ಕಿರುತ್ತೆ ನೋಡಿ. ಕೇಳಿ ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕ್ಲಾ? ನಾಡಿದ್ದು ಬೇಡ. 16th ಹಾಕ್ತೀನಿ. 17th. List on 17th in the fresh matters list. Doesn't survive. Next.
Petitioner appointed junior assistant in year 1998 as credential A. Then annexed B Malati promoted as my senior assistant in year 2003 by the second respondent. After lapse of Malati 9 years, Malati annexed D has been issued.
What is that?
Without issuing Malati wrongly.
What is that?
Wrongly given promotion to the Malati petition.
Erroneous promotion.
Oh.
Promotion to what?
Recover the Malati amount, excess amount paid to the petitioner.
Recovery we will set aside, but promotion if you are not entitled,
Promotion
you
is
can't direct.
but that is confirmed by the Malati second respondent and excess C Malati.
Dates ಹೇಳಿ ಮನೆಕ್ಷ.
And excess C pays for.
Who gave a representation for promotion?
Petitioner. India 2000 Malati.
2003. Promotion junior assistant to senior assistant.
Senior assistant.
Syndicate passes a resolution.
Annexed C resolution passed by the syndicate. That is approved by the first respondent.
Government also.
Then government
the vice chancellor.
First respondent university. After 9 months, second respondent, my lord,
No, no, we can't say that you will be entitled to straight away promotion. What is the criteria?
Criteria, my lord, pass resolution, my lord, pass execution, my lord.
Criteria from junior assistant to senior assistant rules ಅಲ್ಲಿ.
Regulation ಇಲ್ಲ. Rules and regulation not at all CR or
statement objection. In case of promotion, my lord, he has to do graduation. He has to do
1 minute. Objections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ. 7, my lord.
As per my instruction, there is no C and R rules, my lord, that is no shift, my lord.
Where are the rules? C and R rules ಅಂತ ಹೇಳ್ತೀರಾ? Para 3.
I will produce, my lord. The portion of the, my lord, copy of the produce along with statement of objection.
Senior assistant is graduation, is it?
Wherein, my lord, is clearly stated.
What are you? Graduate.
Well, PhD. But the promotion is concerned, my lord, there is no C and R rules, my lord, graduate is not necessary.
And what is the C and R that is referred to?
That is only direct recruitment, applicable to the direct.
Promotion of clearly ಬಡ್ತಿ ಅಥವಾ ಪ್ರತಿ ನಿಯೋಜನೆ.
Let them produce my C and R rules, my lord.
Promotion ಎಲ್ಲಿ? To promote someone, where is the C and R? List the matter on 22nd at the request of the counsel for the respondent. You shall place the C and R rules necessary for consideration of the issue in the list. Next. Yes, Vijay Kumar sir.
My lord, the ranking in the seniority list of scientist 1, my lord, is under challenge. As per the direction issued by the Honorable Court, my lord, his ranking was determined with date of eligibility. My lord, that's had to be, my lord, altered.
Intermodal idea.
Lord, there is no intermodal, my lord.
What has happened today?
Lord, as on date, he has retired from service. But he would be entitled to the benefit of promotion, my lord, pursuant to the date of eligibility that has already been assigned to him.
Where is the order of this court assigning date of seniority, date of eligibility?
Lord, the two judgments, my lord, that is at page annexure, page 40, my lord.
Prospective regularization.
Lord, this is the order that is on 29/1/2001, my lord. Page 48 is the paragraph, my lord. For the reasons aforesaid, the petition is dismissed, holding that the petitioner's appointment in the post of scientist assistant shall be treated as regularized on and with effect from 24/8/92 in the pay scale given in the respondent's order date at annexure F dated 22/8/92. Lord, this is subsequently one more order, my lord, page 49. Lord, page 52 is the relevant.
Come to page 56, sir.
56, my lord.
Prefix seniority and extend necessary promotions, keeping in mind endorsement, so and so.
So these two orders are the basis on which my date of eligibility was, my lord, assigned.
Who appears for the respondent? DM Bundy. Heard the learned counsel appearing for the petitioner. There is no representation by of the second respondent. Awaiting his appearance, list the matter on 17th. In the event he would not be present, orders would be passed here, hearing and considering the submissions of the petitioner. Next. English translation.
This matter, my lord, and told increment has been withheld without there being any counter. Lord, the petitioner, my lord, was working with the professor in the
72 in the
Yes.
In 2004, my lord, the departmental inquiry was held and petitioner was kept under suspension. And
All right.
the order of vide annexure A came to be passed, my lord. The relevant page is page number 19, page number 17. Lord, his pay and grade is reduced from professor to reader. His pay will be fixed at the maximum pay scale of the reader. He will not be entitled for any promotion in the future. His suspension period is treated as leave. He will not be entrusted with any administrative and examination work in the future. This is the operative portion of the order. Thereafter, my lord, the vide annexure B, my lord, the pay scale was revised, and my lord, he was paid 58,980. And my lord, at the time of retirement, his scale was, my lord, 62,580. Page numbers 20, my lord, annexure C.
How is the pension fixed?
My lord,
What is the last drawn pay?
62,580.
Where do I get that?
My lord, page number 20, annexure C. My lord, column number 1. That's the basic pay. Net salary is, my lord, 69,329.
Page 20.
Page 20, annexure C.
69,329.
That is net salary. Basic salary is
62,580.
Please, my lord.
What is the pension? Where is the PPO, pension payment order?
My lord, thereafter, my lord, pension was not disbursed. We made a representation.
All right.
We
Pension
filed-
is paid when?
My lord, pension, my lord, now, my lord, is receiving pension with the, as per, my lord, 52,390. Impute order is at page number 39, annexure J.
Fixation of your scale. Consequent or punishment?
Please, my lord.
Where is the order of punishment?
My lord,
Page number 17.
Page?
17.
Maximum pay of leader.
Lord, there is no.
Have you challenged this order?
Please.
What happened to that?
challenge? And my lord, by the time the petition was decided, my lord, he was already retired from the duty.
Order copies are with the statement of objection.
No, that's all right, but
Annexure B, R2 minutes.
what happened to the writ petition?
Writ petition partly allowed.
ಏನಂತಾಗಿ?
Item number 1 and 2 were retained, my lords. Sustained. And item number 3 and 5 does not survive for consideration, my lords, because already they have attended as a superannuation. Item number 4 was set aside, my lords.
Where do I get that?
Let's page annexure R2 minutes. The operative question last.
R2 ಇಲ್ವೇ ಅಲ್ವಲ್ಲ? Order ಕೊಡಿ.
Sorry, minutes.
Promotion not entitled to.
Please, minutes.
Suspension period to be treated as leave.
Please, minutes.
Will not be entrusted with administrative work, partly allowed. Fixation of pay scale. Confirm ಮಾಡಿದಾರಲ್ಲ penalty ಏನ್ ಮಾಡೋದು?
My lords,
Thereafter, my lords, there was inadvertence. Probably his pay scale was revised, and he was paid the excess next scale amount, my lords.
there should be
For
a
which
specific order for withholding the increment as per Rule 51 of the KCSR. And the page number 32, my lord, that's the basis for the withholding the increment, that's the audit report.
Audit report, was not the audit report a part of this order?
My lord, it was furnished only after, my lord.
Furnished Allah, when was it passed? Date of the report?
Date, my lord, is not 2009-10, my lord.
9.
2009 and 10. pertains to
This
2009
court
and 10.
coordinate benches passed this order on June 2015.
Please, it was not.
Everything is confirmed.
My lord, but there should be a specific order for.
Arre, you should have told the court that passed that order, sir. Appropriate ಅಂತ ಬರೆದಾಗಿದೆ already.
Please, my lord.
ಮತ್ತೆ appropriate ಅಂತ ಬರೆದ ಮೇಲೆ what can I do now?
Cannot be considered as withholding the increment, my lord, because there may be a revised, there may be increment in the same post.
No. ಈಗ now penalty is imposed in 2008 and 9, which formed a part of this order. After that, what did you do?
lords, after that, my lords, the audit report was sought to be
2009-10 audit report, sir.
Please, my lords.
Yes.
Thereafter, my lords, in the year 2013, my lords, they filed another writ petition with an seeking a direction to the respondent university to submit the audit report, my lords, which came to be allowed.
All right.
And thereafter, the audit report was also furnished to the petitioner. My lords.
All right.
Thereafter, my lords, in the year 2015, the punishment order was partly sustained. Thereafter, my lords, during that period,
Continue to that.
Thank you.
But a pure collection of the family, that is why not,
Thank you, Lord.
Yes, sir.
One matter, 330 laws. I have wrongly moved in quota number 4 laws. It is an election matter. My nominations have been rejected on the ground that ಠೇವಣಿ ರಸೀದಿಯನ್ನು ಹಾಜರು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ. The nomination has been rejected.
ಬೆಳಗ್ಗೆ ಆಗ್ಬೋದಾ? ನಾಳೆ?
ಅಂದ್ರೆ ನಾಳೆಗೆ ಅವರು ಅದನ್ನ ಫೈನಲೈಸ್ ಮಾಡಿ ಇದು ಮಾಡ್ತಾರೆ.
Serve on the state. Serve on the state.
Yes, sir. Copy has been served.
Anybody wanting adjournment, tell the court officer. Yes. Madam, 128, Kavita madam, 128, the learned counsel for the petitioner files a memo seeking to withdraw the petition. Disposed as withdrawn.
Serial number 19, since there is urgency, I request for handling of
19. Yes.
serial number 19.
Any other adjournment here?
Officer?
Court officer.
हाँ सर.
Madam, serial number 63 next week, madam.
63. ತಾವು ಸರ್ ಸಂಗ್ರಾಮ್ ಕುಲಕರ್ಣಿನ?
ಹೌದು madam.
ಸರ್ 22nd ಹಾಕೊಡ್ಲಾ?
Okay madam.